from item number 11, my lord. The government has filed the affidavit, my lord. We'll give the reply within a week.
Number 11. Yes, what is it?
But we have filed the affidavit. District Commission has filed the affidavit. We'll give the reply within a week.
They have filed affidavit. Then
We'll have to give a reply.
ask your junior to mention. I'll give you an opportunity. I don't give adjournment at these in these aspects.
Your Lordship, I'm going to mention item number 3.
Yes.
This is the petition number 1 expired. So we have filed an application for substitution. But
You have filed an IA.
that is the let this IA become along with that.
You have filed. It is numbered.
It's
Mr. A.
numbered as
Dasgupta, the Learned Senior Counsel, submits that
9640.
in the instant writ petition, an interlocutory application has been filed on account of the death of the petitioner number 1. List the matter again on 9th of September 2024, along with the said interlocutory application. No, not necessary. It is already there in the list.
Serial number? Did I mention?
No, I am fixing it on 9th of September.
For withdrawing and writ petition, my lord, I want that the matter be listed tomorrow, my lord. Writ petition.
Withdrawal.
Deeply obliged, Your Lordship.
Please, of course. I pray for listing 2 writ petition for withdrawal.
Withdrawal.
I'd like to mention an item for listing motion. I have filed the writ petition today. There is an urgency in the matter. Kindly, it may be,
Today. Tomorrow, why?
there is an urgency, Your Lordship. The petitioner's house has been sealed by the officers of the Enforcement Directorate, and the daughter's admission process is going on. So she requires some documents which is locked inside the house, Your Lordship.
Okay, we'll have it today.
Item number 1, top of the list.
Yes, this is pertaining to the other one, no?
Yes, Lord, this is MHT case filed after 18 years in Gualpada, and United India Insurance Company filed objection, preliminary objection before filing WS, and that has been rejected. This order dated 21/3/2023 has been challenged before this honorable court.
No. Oh. Yes, there was another judgment. There was another judgment of the Supreme Court, no?
Rohit and Company versus Khatun B and another.
Now, when you filed this application, did the other side get an opportunity of filing a reply?
We have filed the petition before the Honorable Tribunal, Gualpada. And other side, they have got the copy of the petition. And it was heard both the sides, and on hearing both the sides, Honorable Tribunal rejected our petition. This is
Yes, Mr. Sahu, what do you have to say?
Even if, delay is there, but section 166(4), which speaks about the report filed under section 156(6), that can be treated as a claim petition.
This is now, 2019.
Yes,
this is applicable.
This is for 2019.
first of
But
April
what about the
2020.
earlier one? This happened only in 2019.
Yes,
That a report or an accidental report can be very well taken as a final report, as a claim. But was that similar provision there earlier also?
there was,
So wait a second.
old book is there, the old book, prior to 1919,
Vehicles. Hello.
Lord, I'd like to rely on judgment of Madras Judicature on this particular point.
Rules.
158.
Hmm. 158.
158, subsection 6.
158.
The book prior to 2019,
Yeah, go get a finish. Show me that book. Here the incident happened when?
2004, I think.
2003.
2003.
Okay, then
Earlier, this provision was also there. Only 2019,
Now, earlier 166(3), which was there.
Yes.
That was omitted by that same amendment by which 158(6) was brought in. See this. 166(3) at that point of time was removed.
But it was brought in the year 1994.
Understood?
Mm.
The same date on which 158(6) was brought in.
Yes. Yes,
Therefore, 166(3) was removed.
yes.
It seems to be that why it was removed.
But yet that at the date of accident, these provisions were there.
It was
150
discussed in the
158.
judgment of Purohit and Khatunbi, para 7.
Huh?
Honorable Supreme Court has discussed this particular thing in para 7 of Purohit and Company versus Khatunbi.
He judges, no? He judges.
But it's okay, but whether after filing this, opportunity was given to the respondent or the claimant to explain the delay.
Or-
To explain the delay. Because that is a very relevant aspect. Normally in a claim petition, there is no mention of explaining the delay. It is in a particular form. But when this application was filed, whether there was an opportunity being given to the respondent to explain the delay, the claimant.
by
Because
file-
if there is an explanation, it will then be considered. Because here in this case also, there was an opportunity wherein his delay, he has mentioned it, which was not accepted.
By filing our objection, my lord, by filing our objection, the opposite party got the opportunity to oppose us because we have objected it. This is number one. Number two, while filing this civil division petition, we have again
This is a
forwarded
different
this-
thing, not here. There.
we have
Because
forwarded the
without,
order.
as of now,
We have forwarded the order there as per court's
Understood.
direction.
whether that may be, but the question is as to whether there was an opportunity given to explain the delay.
Our objection, they rebutted our objection by explaining in what.
By explaining whether there was an opportunity given to explain the delay. Yes, 166(3), there were, although that period is not mentioned, but if it is an unreasonable period of time, then obviously, because here the court is not exercising the power on the basis of a statute, but the exercising on the power saying that we are not going to entertain this for whatever reason. The reason is that this is an unreasonably delayed.
and
So whether the court had put them to notice about that to explain. If the court had not done it, would it be proper on the part to go into that aspect of the matter at this stage?
Here in the impugned order, heard the learned counsel for both sides. So they have given their objection. They have tried to
Have
impress,
they filed an objection explaining the delay?
not provided any copy of that.
We do one thing, we set aside this order, directing the MAC tribunal to give them an opportunity to explain the delay. And thereupon they decide on that aspect, taking into account the judgment in Purohit's case.
As well as that 166(4). That aspect,
Purohit's case, 158(6) was duly considered.
no, my lord, at that time it was not.
Yes, they have duly considered the Purohit's case. They have taken the note of the judgment in the other case, 96 judgment.
Yeah.
In Purohit's case, they have duly taken note of that because this is a recent judgment of 2017.
Yes,
Here it has gone into another aspect of the matter.
Yeah.
That whatever may be, you cannot, maybe there is no limitation
Honorable
filing,
Supreme Court,
but one has to also take note of various other aspects.
Yes.
Just for example, in Industrial Disputes Act,
yes,
Section 10, there is no mention when a dispute can be raised under Section 10. But then also, the courts have all along held that if it is a stale dispute,
yes.
then in that regard, the authority, the court can very well set aside it, hold it. But here, it doesn't appear that there is any explanation from the claim petition, or there is no any opportunity was given to explain. Let them explain, I think that would be better, but here, that is the basis on which Purohit's case is based, not on the basis of 158(6) or anything. But that was a duty of the officer. That was the duty of the police officer as per 158(6). They have not done it. If they have not done it, then the claim petition ought to have been lodged at that point of time in 2001 itself. But how do you prove it? Unlike a mechanism now provided as per the 2019 Act, as to how it is to be done, how do you prove it at that point of time? Nowadays, what is the mechanism? You file, the accident happened, there is first a report, whereby that report is being sent to the victim as well as to the insurer. Insurer is asked how much compensation you are going to pay. If the insurer may pay the compensation then, or may say that no, we are not. Then in that regard, within 60 days from the date of the accident, the charge sheet has to be given. On the basis of the charge sheet, the detailed inquiry report is to be filed. Once it is filed, then the police concerned would be advised by the tribunal, then look here, we are here, kindly get hold of the claimants. This is the proceedings. The claimants will be duly informed of about the DIR being filed. When the DIR is being filed, then these persons concerned may file a claim or may not file a claim. Now, if they don't file a claim, the DIR becomes the finally, it would be treated as a claim. And thereafter, in another judgment, the recent judgment of the Supreme Court says that they may file a claim in another proceedings, just for example, in Guwahati, and the DAR is being filed in Lakhimpur, then the DAR would be transferred to Guwahati. This is the mechanism now. But that mechanism was absent in terms with 158.6. So the question out here, which has been raised by the learned counsel, is irrespective of all these things, it is a stale claim. And as such, the court ought to have taken note of that aspect. And merely on the basis of there is no limitation provided, you cannot take note of a stale claim. That's your submission.
But in the previous case, the accident occurred during the Act of 39.
Huh?
Accident occurred during the existence of Act of 39. That is why perhaps
Understood.
that aspect of the
Accident occurred, but then also there might be, the police officer may not have done.
it
But if what stopped you for approaching the authority for 18 years? But one has to also take note of as to whether these people have the evidence, whether they have any files. That is also another very important aspect which needs to be looked into.
Impact of delay on opposite parties, prejudice to the opposite party's rights. Impact of delay on the opposite party is also there.
Minister,
A and thus.
and so the learned counsel appearing on behalf of the petitioner, none appears on behalf of the respondents. In spite of service of notice, this court, by an order dated 21/5/2024, taking into account the issue involved, had requested Mr. S. Sahu, the learned counsel, as to whether he would be inclined to assist this court, to which Mr. S. Sahu, the learned counsel, have readily agreed, for which, and accordingly, on 21/5/2024, Mr. S. Sahu was duly appointed as the amicus curiae in the instant proceedings. The instant proceedings, in the instant proceedings, the challenge made is to an order dated 21/3/2023, passed in MSC case number 339/2021, wherein an application filed by the petitioner herein, who is the respondent, for rejection of the claim on the ground of delay, unreasonable delay, was rejected. For understanding, for appreciating the dispute involved, it is relevant to take note of that on 17/9/2003, an accident on account of an accident, the respondent herein, who was traveling from Dudhnoi to Ozia as a passenger involved in the vehicle, the passenger suffered from injuries on thereupon on 7/9/2021, almost after 18 years, the application was filed, the claim petition was filed, seeking a compensation of rupees 8 lakhs by the respondent herein. The petitioner company, upon receipt of the notice, appeared and submitted a preliminary objection to the maintainability of the said claim proceedings. On the ground that the said claim proceedings was filed after 18 years, 4 months. It is not known as to whether the respondent herein filed any objection to the said said petition, raising preliminary objections, or as to whether the tribunal asked the claimant to file any application, file any affidavit explaining the delay in approaching the claims tribunal after a period of 18 years. Be it as it may, by an order dated 21/3/2023, the learned tribunal rejected the application for dismissal of the claim petition on the ground of delay, and being aggrieved the present proceedings. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submitted that although section 166(3), which earlier mandated filing of the claim proceedings within a period of 6 months, was removed by the amendment made on 14/11/1994. But the learned tribunal ought to have taken into consideration that the dispute in question was a stale dispute. In addition to that, the learned counsel also submitted that approaching the tribunal after such a delay, unexplained delay, makes it very difficult for the petitioner to have a proper defense in as much as there are no materials available, no witnesses available, no witnesses, etc. And there is no records available, as well as witnesses. For the respondent, for the petitioner company to take up a reasonable defense, which is also a facet of the principles of natural justice and Article 21 of the Constitution. Therefore, referring to the judgment of the Supreme Court in the case of Purohit and Company, therefore referred to the judgment of the Supreme Court in the case of Purohit and Co. versus Khatunbi, reported in 2017 4 SCC 783. wherein the Supreme Court had rejected the claim proceedings on the ground of it being stale and accordingly to be treated as a dead claim. On the other hand, Mr. Esau, the learned amicus curiae, submitted that by the amendment made on 14/11/1994 to the Motor Vehicles Act 1988, two important aspects, two 1994. Section 158(6) was inserted and section 166(3) was removed. The Learned Counsel therefore submitted that by virtue of inserting section 158(6), a statutory obligation was cast upon the police officer to submit the report before the claims tribunal and along with another report to the insurer in question. He therefore submitted that upon the submission of the report by the concerned police officer, the tribunal was required to treat the same as a claim proceedings. It is therefore submitted that as the report would be submitted by the police officer and would be treated as a claim proceedings, the legislature, in its wisdom, have removed section 166(3). Therefore, the Learned Counsel submitted that the Learned Motor Accidents Tribunal, the Learned Counsel further submitted that the Supreme Court in the case of Dhanalal versus DP Vijayvargiya and others, reported in 1996 4 SCC 652, had also duly taken note of the said aspect of the matter and had accordingly come to an opinion that the claim proceedings could not have been rejected on the ground of limitation. I've heard the learned counsels appearing on behalf of both the parties, appearing on behalf of the petitioner as well as the learned amicus curiae. From the said averments made, from the said submissions so made, the point for determination which arises as to whether the learned tribunal was justified in rejecting the application by the application for rejecting the application, questioning the maintainability of the claim proceedings on the ground of delay by the impugned order dated 21/3/2023. It is relevant to take note of that prior to 14/11/1994, (166(3) of the Motor Vehicles Act provided, section 166, that no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the incident, provided that the claim tribunal may entertain the application after the expiry of the said period of 6 months, but not later than 12 months, if it is satisfied that the applicant was prevented by sufficient cause from making the application in time. This section 166(3) was deleted by the amendment made on 14/11/1994. By the same amending act, section 158(6), subsection 6 of section 158 was inserted. Which reads as follows. Report কৰি দিব হা সেইটো আগৰ আছিল এতিয়া নাই কিন্তু 2018 আগৰ A perusal of the said above quoted subsection 6 of section 158 the officer in charge of the police station, upon receiving any information regarding any accident, including death or bodily injury to any person, shall forward a copy of the same within 30 days from the date of recording of the information, or as the case may be, on completion of such report to the claims tribunal having jurisdiction, and a copy thereof to the concerned insurer, and where a copy is made available to the owner, he shall also, within 30 days of the receipt of such report, forward the same to such claims tribunal and insurer. Where is it mentioned that it is to be treated as a claim petition?
166.4. 166.4.
It will also be seen that in terms with section 166.4, which was also amended by the amending act with effect from 1411 to 1994, that a claim tribunal shall treat any report of accident forwarded to it under subsection 6 of section 158 as an application for compensation under the Act of Motor Vehicles Act 1988. From the provisions of from a conjoint reading of section 158.6 read with 166.4, that certain statutory obligations have been cast upon the officer in charge who has received the information, as well as to the concerned insurer upon receipt of a copy from the officer in charge to forward the same to the claims tribunal. To the officer in charge as well as to the owner insurer. If this report is being submitted The claims tribunal shall treat such report of accident as an application for compensation under the said act. It is, however, not known from the facts involved as to whether any report was sent to the claims tribunal by the officer in charge, by the officer investigating the, or by the officer in charge of the police station, or by the owner of the vehicle in question. The statutory obligations which are cast upon the official authorities are obligations which are required to be performed. However, if such statutory duties, obligations are not performed, and the person who otherwise is required to enforce, and a person who otherwise is aggrieved by the non-performance of that statutory obligation, so cast upon the public officials, has also to approach the appropriate authority within a reasonable period of time. Failure to do so amounts to either waiving the rights which accrues on the basis of the provisions of 158.6 read with 166.4. There is no explanation in the claim petition. This court has also taken note of the claim petition, wherein there is no explanation as to whether the petitioner had at all approached the officer in charge for sending the report, as well as had made any inquiry regarding the proceedings, regarding any proceedings pertaining to the accident of the petitioner. Another very important aspect of the matter, as could be seen from the judgment of the Supreme Court in Puruit and Co. Supra, that irrespective of there being no period of limitation, a stale dispute cannot be a subject matter of a claim proceedings. Paragraph number 13 to 17 of the said judgment, 18 of the said judgment being relevant is reproduced hereunder. We, however, find it, this court, however, finds it very relevant to take note of that in the claim proceedings, there was no mention whatsoever. There was no explanation of the delay of 18 years in approaching the tribunal. It is also known as to whether the respondent, the claimant, was at all given any opportunity by the tribunal to explain the delay as to why, explain the delay of 18 years in approaching the tribunal. Under such circumstances, this court is of the opinion that the learned tribunal have mechanically applied the law in the case of Dhanalal Supra in passing the order dated 21/3/2023. The aspect which the learned tribunal ought to have looked into is as to whether the claim so made was a stale claim, taking into account that there was a delay of 18 years in approaching the claims tribunal. In that regard, accordingly, this court, taking into account that there was no materials available, and taking into account that the learned tribunal did not consider the said aspect of the matter, or for that matter, did not seek an explanation from the claimant, remands the matter back to the learned tribunal to decide afresh the application filed by the petitioner for rejection of the claims tribunal the rejection of the claim proceedings afresh. The order dated 21/3/2023 is set aside and quashed. The learned tribunal shall decide afresh on the touchstone of the observations so made by the Supreme Court in Purohit and Co, as well as the observations made herein above. With the above observations and directions, the petition stands disposed. Taking into account that there was a stay proceeding, taking into account the above, as this court by an order dated 1/5/2024 had stayed the further proceedings of MAC case number 339/2021. The said stay order is vacated and the the parties herein are directed to appear before the learned tribunal on 18th of September 2024. It is also to be noted that as the respondent herein with the claimant is not appeared before this court, the learned tribunal shall also issue notice prior to proceedings in the matter. We appreciate this court before concluding appreciates the assistance so received from Mr. S. Sahu, the learned amicus.
All right. My lord, she may be given an opportunity to explain the delay, my lord,
Yes.
because when accident occurred, no limitation was there. And that is why registry did not ask for any explanation.
That is why I'm asking you for filing asking for limitation. There is no explanation, so they will, on basis of application, thereby giving it a line to litigation, thereby giving an opportunity to the claimant to explain the delay in preferring the claim proceedings after a lapse of 18 years from the date of the accident.
Item 2.
Yes, what is this?
That's that matter that.
Oh, yes, that matter.
But in this case,
Yeah,
if I may submit the entire issue.
Yeah, yes,
In this case, when the impugned order was passed, on the date the impugned order was passed, the 45 days period, maximum period for filing the WS had already expired. Now, the only way in which the tribunal could have even passed any order, reasonable order, describing the exceptional circumstances or whatever, that would have been on the basis of an application. Whatever has been stated in paragraphs 10 and 11 of this petition, that the petitioner could not contact his engaged counsel because of ABCD reasons. That was not before the learned tribunal, because no petition was filed. A prayer, the impugned order has recorded that there was a prayer made that the counsel is newly engaged. He has filed the wakalatnama and he seeks time to file the WS. That is all. That was an oral prayer, made. There was no application made for placing any reasons, because the tribunal.
let's see his application before the tribunal. Where is it?
There is no application.
No application.
Verbal prayer made by the learned counsel also. As the petitioner has not get that time to.
No. Whether did you file an application for extension?
The petitioner has not filed any application for extension of the filing time for WS.
Then?
But his counsel also made a verbal prayer.
No. We dismiss it right away. Heard lahu. In file an application, where is the question of this? How can you approach this court? Rightly done. Heard Mr. N.H. Losko, the learned counsel appearing on behalf of the petitioner. Mr. A. Ganguly, the learned counsel appears on behalf of the number 1 and 2. The instant petition has been filed by the petitioner being agreed by the order dated 14/6/2024, whereby the learned presiding officer of the Recovery Tribunal, Guwahati, had rejected the time for filing written statement, had rejected the request for filing written statement come evidence on affidavit on the ground that though on the ground of section 19(5),
Lordship, 19.5 Roman 1.
On the ground of section 19.5 Roman 1 of the Recovery of Debt and Bankruptcy Act 1993. It is seen from the impugned order itself that on 2/4/2024, the respondent, the petitioner herein who was the respondent in those proceedings, had appeared by filing wakalatnama and sought time for filing a written statement cum evidence on affidavit, which was permitted. Thereupon, the matter was listed on 2/5/2024 and 15/5/2025. But no written statement cum evidence on affidavit was filed. Even on 14/6/2024, there was no written statement cum evidence filed, and no written statement was filed. And verbally, time was sought, which was rejected by the learned tribunal. In view of the above, this court finds no ground to entertain the instant writ petition. In view of the above, the conduct of the petitioner does not inspire this court to entertain the instant writ petition by exercising the writ jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the instant writ petition stands dismissed. Be that as it may, the dismissal of the instant writ petition shall not preclude the petitioner to avail such remedies as are available under the provisions of the Recovery of Debt Act 1992.
Then interim order staying the proceeding.
Interim orders passed earlier stands vacated. Parties are directed to appear before the learned Debt Recovery Tribunal on.
No, there is a date fixed, my lord. I'll
When?
inform. There's a date. I'll inform the.
The interim order passed earlier stands vacated.
21, top of the list.
Please, your lord. My lord, may I seek some,
This is power lordship by notification whether Assam Land Revenue can be amended or not.
Huh?
By BTC lordship notification, issuing notification whether amendment of Assam Land Revenue can done or not, lordship, on that point.
my lord, on behalf of the advocate general, my lord, may I seek some accommodation, my lord?
Why?
BTC authority has entrusted this matter with the AG, my lord. He was just there. My lord, he has some problems today, my lord. And this has been handed over today, this morning only. But 1 week's time has been, my lord.
What notification has been issued?
By notification lordship, Secretary BTC was given the appellate authority lordship.
Have been given the
Even land matters lordship. And the order which I impugned in this writ petition was passed by Secretary BTC. My case is that lordship, Secretary BTC has no jurisdiction. It has to be, they ought to have challenged the SO's order before Assam Land Revenue. That
you mean
is-
the notification?
Lordship, that is in affidavit in opposition by the BTC, page 47. lordship.
Okay.
47. lordship.
This I have seen it. Then,
At respect, lordship, the BTC was asked to argue this
oh,
matter.
that I know.
My lord, all these issue will be responded to by my lord.
Huh?
The issue raised will be responded to, my lord. My lord, only my prayer is, my lord, the AG has sought some accommodation, my lord.
So?
He was right there, my lord.
You have given it to the AG, that is, he should be present when the matter is called.
My lord,
If he is
only
not
one
there, how do I
thing,
help it?
since the issue is of far-reaching implication, my lord.
Hmm?
Lord, the issue is of far-reaching implication, my lord, in terms of PTC, my lord, and sixth schedule, my lord. And the whole purpose of the sixth schedule will be diluted, my lord, if it is interfered with. Especially on the question of land rights, my lord. Therefore, my lord, the BTC authority has seriously pondered over this matter. Only 1 week's time, my lord. Everything will be responded to, my. He is also the senior signing counsel of BTC, my lord.
Where is the first order? Page 27.
Settlement, yes, lordship, settlement order, officer's order, lordship, dated
Huh?
27/2022.
Settlement officer's order, 21/7/2022. This was the first order which was passed against you,
Yes, lordship. No, in my favor, lordship.
settlement officer. Then how does the BTC secretary come in?
They preferred appeal before PTC, lordship.
Okay.
3 grounds I have challenged, lordship. My first challenge is there is no jurisdiction. Second, lordship, no issue, notice was issued to us, lordship. And third point is that, lordship, the appellant number 2 was dead, lordship, at that relevant point of time. The order was passed in favor of a dead person, lordship.
I have submission.
Yes, one. We wait. Where is the principal secretary's order?
Page 32,
30?
annexure 4.
Mr. Rabha, one thing, let us not go into other aspects. Even if we take the notification, an appeal lies from the Director of Land Revenue to the BTC Secretary. Very well. That is another aspect of the matter. But how does an appeal lie to the BTC Secretary from the settlement officer?
Bone of contention, my lord.
Huh?
This is the bone of contention, my lord.
No. How does it lie to the settlement officer? If we go by this notification, the Deputy Commissioner is outside the jurisdiction of the BTC. No problem with that. For which you have the Director of Land Revenue. You say from the Director of Land Revenue, an appeal lies to the BTC Secretary. Okay. That is another aspect of the matter which may be taken up in some other matter. But how an appeal from a settlement officer lies to the BTC Secretary? Even if we take the notification. Because the notification does not say in any manner that from an appeal from the settlement officer will lie to the BTC Secretary.
Some ambiguity, my lord.
Huh?
There are some ambiguity, my lord, in the notification.
Yes, Mr. Mahmood, you expressed urgency in the matter.
Kindly see their prayer. Here, they have made completely new thing that we have challenged the notification. But there is nothing in the prayer.
For what?
Notification regarding notification, there is no.
No,
prayer.
it's okay. Notification, let us assume that the notification is there. But the notification only says that the Deputy Commissioner will be the BTC, the Director of Land Revenue. And against that appeal lies to the BTC Secretary. Okay. But what about the settlement officer?
My lord, that is the question to be answered and decided by your lordship. But my submission is this: what is their locus? Who are they? These petitioners have no connection even far away from the disputed land. They are nobody. Totally a third person has filed a case.
Is there sale deed?
That
Is the
false.
sale,
That
whatever
is
may be,
false.
there is fraud, it's okay. Can the revenue authority declare a sale deed to be bad?
The revenue authority said for the time being, lordship, that should be taken, that should be believed by this honorable. Because that is before your lordship. Now, whether it is genuine or not, actually in terms of civil law, then they may challenge that decision. But so long that is not challenged by them, court should believe this because they are the officer. They are public officer. Public officer saying their deed is false. And there is no contrary order from any competent civil court. So that has gone.
They have a sale deed in their favor.
They have mutated their names along with us. But what is the basis that is not there?
The basis is the sale deed.
Sale deed is found fact.
Understood, but that is, can the revenue authority decide that?
I have little knowledge. The revenue authority is saying his sale deed is fact. Now, no competent court has declared that no, it is not fact. So till the competent court has declared the same as genuine, court should believe that because this honorable high court cannot go into disputed matter. They are saying it is fact. Court should believe it fact because there is no contrary order to any from any civil court. Thirdly, when there is a finding that their sale deed is fact and their ramjari on the basis of that fact sale deed is illegal, that was inquired into by assistant settlement officer. Assistant settlement officer issued notice to both the parties. Now they did not face that notice. They could say what they are saying, but without appearing before the ASO, there, when the matter is sub judice before the assistant settlement officer, he issued notice to both parties, come here and say your submissions. He also issued notice to senior sub registrar that whether this deed is genuine or not, you also submit your report. So in this position, they directly went to settlement officer. They did not fetch the ASO. In the meanwhile, the senior sub registrar sent the report that their deed is fake. And our deed is found genuine. So court should not believe this unless there is any contrary order.
No, that was believed by an authority which had no jurisdiction. Problem arises there,
They
na?
are revenue authority.
Understood, but
Senior
that revenue
sub-registrar
authority
itself-
did not have the jurisdiction.
Senior sub-registrar is the custodian of all sale leads.
Understood, everything is understood. But as of now, there is a sale deed.
I do not know. Sale deed is there, but it is found false. Fake.
Who can declare a sale deed to be false?
Yeah, that can be, for the time being, your lordship should believe that.
How?
Yes, he is saying it is fake.
Who says?
Senior sub-registrar saying it is
Senior sub-registrar only says that we don't have records of that
record.
document.
That means what? But my document is much older, but the record is there. So presumption goes to in my favor. Secondly, they did not fetch the ASO. This is very important matter. If a case is pending before judicial magistrate first class. But the accused person directly went to session judge and filed a petition that this case is pending there, you take up the, is it permissible under law? Because there is no finding from the ASO. Or if only there is the finding, then he can go as settlement officer. But it was under his inquiry, he issued notice to them. Also issued notice to us. Also issued notice to senior sub-registrar.
No, is the order passed by the settlement officer without hearing you?
Nobody was heard, or only record was finished. Can you go through the order?
They have filed their affidavit.
We have
opposition,
filed the
lordship.
petition.
They have
There are
filed
no record of,
objection,
no,
lordship.
no. Where is,
Page
so and so,
page
where is
24,
that?
your lordship kindly go through. Written objection filed by the second party, number 1, Shah Alam Talukdar.
Both parties are present. Learned advocate of the petitioner is present and submitted some documents. First, the ASO has already submitted status report. The case in brief is that the land number so and so, so and so, so and so. The opposite party has already submitted written objection. Why you are saying that no? You have submitted written objection.
We have submitted written objection, but officially nobody was heard.
It is there.
It
Because
was- we have filed
both
a
parties
petition.
were present.
We have filed a petition that this thing has gone because when the matter was pending for decision, they jumped to another higher court and filed the petition, got the order. So we filed petition. Thereafter, the report was called from by SO. And that is page 27, kindly see, page 27. Where is records put up today, which was fixed for ASO's report, hearing and delivery of final order, both parties are present. Now, both parties are present, learned advocate on behalf of the petitioner is present and submitted some document through Firisti. The ASO Bugriwari has already submitted status report. Hide letter number so and so, dated so and so. The case in brief is that land measuring. Now here lordship would say the ASO has submitted report, but ASO was not given chance to decide the matter.
Patta has been issued to both the parties.
Namjari Patta has been issued,
To both the parties.
both the parties, and their names have been included. Originally, there are two names were Shah Alam Talukdar and Shah Jamal Talukdar. As per the gift deed, their names were there. But later on, they made a fake deed and that was produced. So their names were also included in the Namjara along with us.
Well, I am asking you about the part in the,
Namjari part,
in the
Namjari part,
patta, whether their names were there.
Namjari in mutation,
Yes.
Patta.
Patta,
Page 31.
nobody will name.
Page 31.
Yeah, page 31, it says, have already
Periodic
been
Kiras
issued,
Patta,
periodic
periodic
Kiras Patta has been issued in the name of both the parties duly signed by the ASO Bagarmari and the settlement officer so and so. Since both the registers there are susceptible and can be termed as false at this moment, the other criteria on land holding as per so and so has been observed. As such, since the title holder is in possession of the entire land, cancellation of the same name of the recorded brother cannot be justified. Although the land measuring covered by so and so is a vacant land, but the name of both the parties have already been recorded as a pattada in the Miyadi Patta in question. Hence, the undersigned has nothing to interfere with the matter for cancellation of the name of the heir from the record of rights.
Where is the Patta? Where is the Patta? Patta, they say Patta in their name. This is mutation. Mutation does not confer any title. Let them produce the Patta. Only saying that Patta is in our name, that is not enough. They filed like a, let them produce their Patta.
There's a patta.
Have not annexed.
Do you have a copy of that?
That there is civil case. We have not filed civil case, but they have taken a plea in their petition that there is civil case, but we have not filed civil case.
Civil case by respondent number 8, Lordship. That was.
Yeah,
later
I am
to
not
withdrawn,
respondent number
Lordship.
8.
He is also a party to that civil
No,
case.
no, no, no.
Lordship.
I am not, I am respondent number 7.
I have the photocopy of it.
Take.
You do not also deny in your written objection that there is a, regard the patta in the,
Not annexed, how can you deny?
no, there is a statement made in the written objection there at paragraph number 2.
The
Page-
affidavit
page
we have
20.
not yet filed. Affidavit we have.
No,
not yet.
not here, there, before the settlement officer. In paragraph number 2, there is a clearly mentioned that the petitioner, first party has obtained both Jamamandi as well as periodic patta wherein the petitioner's name was shown as patta along with the opposite party number 2. In the Jamamandi at the remarks column, it is clearly stated that on Iman as per the Chitha Jamamandi Iman, name of the pattada along with so and so. By the order granted mutation of the land in the name of the petitioners. In the meantime, had filed miscase before the Iman for correction of the record of rights measuring so and so, so and so. Following the Iman has passed an order and issued notice to the seer to appear. That the correction of the record have already been banned by and accordingly petitioner as well as the opposition. If a similar case of correction regarding the name on the basis of they have no jurisdiction to make any further correction. Korean, so and so, so and so.
There are 4, 5, they have not denied in their objection, lordship. They did no comment.
Now tell me another thing. Who has filed the suit?
Filed by respondent number 8, lordship.
Not you.
No, lordship.
Writ petition or title suit? Writ petition. It is filed by them.
Huh?
Filed them by them. So,
Who filed the suit?
the title suit was filed at
8, lordship.
respondent number 8. I am respondent number 7.
Respondent number 8. Who is appearing for respondent number 8? He. You filed the suit.
We are descendant of respondent number 8.
Okay, you filed the suit. That suit was dismissed.
Yes, lordship. The defendant is represented.
Who are you, how are you connected with the petitioner?
Brothers, lordship.
7 and 8 are brothers.
Both of you are brothers. And what is your suit? You don't know. What is their suit?
My lord, in that suit, we are not the party.
You are not parties. So how is it relevant, the dismissal of the suit?
My learned friend knows. I have not.
No, you only produced on the last occasion that.
Because she raised this issue. So I have produced the copy that it was filed by respondent number 8 and that was rejected, that parties were separate. We
that
are
was
not the
different.
party.
So that has no relevance.
Can you see that?
Proper defendant number 1, Shah Alam Talukdar, lordship. Respondent number 7. He is also a party, lordship.
The party, but we have no idea because your suit was dismissed. Whether we have got any notice or not, that is not clear. The names are there. Can you see the names?
See, in this patta which have been issued, their names are there.
Their names are there. That
Then
is,
if the names are there,
if they have patta, then this is the best document. No doubt. Patta is the best document. Namzari does not confer title. But why they did not earlier file this? Or if they file, then only I will be able to answer what is the matter.
no, that
Maybe-
patta was specifically mentioned out there in the ASA's order. In the settlement officer's order. The facts which can be discerned from the facts, from the materials is like this. The ASO initially granted them the mutation.
No, my lord, here is now some tag numbers are given. 69, 187, 188. 3 tags are there. I don't know whether it is genuine or false because they have already filed a false salary.
No, the settlement officer mentions about this patta.
The settlement officer mentioned this patta. Senior sub-registrar also say this is fake.
Senior
ASO also say the fact.
says about the sale deed.
All of them are public servant. So let me submit then one thing, my lord. They have, now they have said this. What is their tag number and patta number? In respect tag number 77. The lordship can list page 17 of their prayer. Their tag number is 77, 187. And lordship kindly say,
See the
Yeah.
patta number? What is the number of the patta?
patta, it is written on 77. Tag 187
Patta.
and patta number 139. Here patta number 195.
No. Yeah, there are two pattas. One is patta number 139 and 195. And 139 old patta became 195 new later on.
One,
And dark number
but
16.
here
would
I
become
have got only
69.
one patta. So here 195, tag number 77, 187. It is there. Then lordship 195 and tag number was 16. 16 is not here. 16 is not here.
16, 69, same dark, lordship. 16
And-
old, new.
And
69.
and
69 is there.
our case was that Our case, our patta is. Our patta is 241. Our patta is 241. And tag number is 339. So 241, I have no, extra copy as an extra copy. Patta. Then our their patta number is 195. Our patta number is 241. Can you see this aspect?
And this is the patta for tag number 195. Patta number 195. What about 139?
139 old patta number, lordship, new patta number 195.
195. Now, our new patta number is
Tag number
241.
old 16 became 69.
Lordship, our new patta number 241. And our tag number is 339. Here, this patta, there is no 339. In this patta, there is no 339. And 339, 344. Here is also no 344. That's why from the very beginning I am saying they are stranger.
Where is your tag number?
Our tag number is, my lord, tag number 339. And here is no 339. Pattern number is 241. Here is no 241.
Where is your document to show?
That is kindly page 52 of my IA.
I consult.
And two plots of land. Two plots of land. So one pattern number is 241. There is no 241. Tag number 339, there is no 339. And another plot we have, that is patta number 241. Here is 195. And tag number, another tag number 77. Here is no 77.
Tag number 77 became 187.
No, can you plus 46? 46 of my IA. First, can you see 46?
Seventy-seven tag is there. Schedule of the
Where is the order of 24/3/2021? That is the main subject matter of the order, no?
three 2020. ASO, lordship.
Hmm?
ASO.
Page?
ASO's order, lordship.
The AS order. Where is that?
That order,
That is the most important order. What mutation was carried out in respect of what? That order is not brought in.
And the ASO's notice page 22 of IA. And
Where is that order 24/3/2021? No, this is the 4/12.
22,
Hey, this, a plot of land measuring 4 katha 5 letter of dark number are recorded in the name of so and so along with Iman and. Now kindly come to page 33 of your order. 33 of the I.
yes,
Now, as per this order
Yeah.
of 24/3/2021,
Yeah.
4 katha 15 letters of land of dark number 69/16
Yeah.
was recorded in the name of the pattada number 3, 4, and 5. These are the persons who are the petitioners hearing. Okay. Along with pattada number 1 and 2, and accordingly record was corrected. Okay. This application, thereupon you filed an application challenging this order before the ASO. Understood. On the basis thereof, miss case number 3/2022 was made.
yes.
Now,
Notice was issued.
while that matter was pending, they approached the SO
Yes.
and saying that, look here, how would the ASO review its own order? So, to decide 3/2022 before the ASO, ASO accordingly decided this thing and held it that it is a case by which it has both persons' names have been recorded in this patta. So we are not concerned with dark patta number 241. We are only concerned with patta number 195. Because this is only in the patta number 195 we are concerned, which later on I think patta number became. This is what dark number 195. It is wrongly written. Yeah. Patta number 195. It was 137. Later on became 39, became 195. Isn't that?
Not only doc number 69, above that your lordship will find according to the note of the chitta, a part of doc number 77. Land measuring 2 bigha 4 katha 5 lesser is recorded in the name of patta number 345, page 33, lordship. Doc number 77 also our name are recorded. After that block, lordship.
They have filed that he cannot review his own order. That is, the lordship is saying like this. But they could say this better to the ASO, that you have passed the order, you have no jurisdiction. But
No.
directly they jumped.
No, they did not challenge that order before the 24/3/2021 order was challenged by you.
And moreover, review is permissible. Review is permissible because on the discovery of new document, new grounds. Suppose at that time, the learned ASO.
Understood, but the power of review is always ingrained in the statute. Where is the power? Nowadays, no.
Giving so many judgments.
No.
That even subsequent developments is a good ground for review. I can show you.
Absolutely, Mr. Mahmood, absolutely. That is a good proposition of law.
Yes.
But to do the review, the power has to be ingrained. Where's the power?
Now, tag number. That power is there, my lord.
No.
Review court's power is also like an appellate court's power. There are also judgments like this. I can show you if your lordship is on that, the review power is applicable. That is MC Mehta's case. And there is also.
MC Mehta is Supreme Court.
Yes, MC Mehta say I have.
It does not say about the revenue authorities.
That is, review power is there.
Moreover, lordship, no affidavit in opposition till date they have filed, lordship. No affidavit in opposition, only IA, lordship.
Okay. So, what my submission is this, there are so many lands in the patta. Why my lands have been there obstructed? Why my land is obstructed from selling or purchasing? Because tag number, only one tag number it is seen, but in one tag number there may be more lands. Our land is only, my lord, here, our lands may be.
Their names were inserted in that patta.
Yes,
This patta has not been challenged.
that patta we have no idea about this, how they got it.
The patta has
Their
no.
names are also there, lordship.
Huh?
Their names.
Your
Our
names are
names may
also
be
there,
there.
which has
Our-
been duly recorded by the settlement
Our
officer.
names are also there in the Namzari.
In the patta, forget about that, the patta.
Patta, in the patta is there, but that is, patta is there, but in patta there are so many dags. Our land is limited lands. Our lands, I show your worship, kindly see page 42. 40, first 40. 40. Here, our lands we want to sell 0 bigha, 3 katha. Patta number of dag number 340. Dag number 77, 345. In dag
This is a different patta. We are not concerned with patta number 241. This is 241. 241 is completely different from this 195. We are concerned only with tag number 195.
This land is
Patta number 1.
prohibited us from selling.
Huh?
This land, this 241 pattas land has been prohibited. Prohibited means status quo order is there. So that has.
Where?
limited by-
Where is the status quo order?
It is passed by Honorable High Court.
No.
Yes,
Status
yes.
quo to be
Right.
maintained in.
That
respect to
lordship
the
may
land,
kindly see page
lordship.
56 of I.
241, I have not mentioned, lordship.
Anyways, you have any problem with 241? We clarify that you sell 241.
In after.
Does 241 have anything to do? Because
Lordship.
your land is 241.
Yes, my
This impugn order, they have lordship made partition and they have created new dark.
Yes, my lord.
patta lordship, keeping lordship these persons in dark also lordship. The order was passed upon the respondent number 8 also. He is a dead person. His legal heirs are there lordship. After passing of the impugn order, the partition was done only in the name of respondent number 7.
Yes.
So new dark, new patta was created and. they
That
are
is
now-
patta number 241.
Now they want to sell the land lordship.
After passing the secretary order, my lord, partition was made without notice to us, my lord.
They have filed affidavit in opposition lordship.
Have also challenged the partition, my lord, before the SO, my lord. After passing secretary order, my lord, partition was made in favor of respondent of 7.
No, that's patta number 241 come in from 195.
Yes, my lord, yes.
How do you know?
Because partition was made, my lord, after secretary passed the impugn order, my lord, in favor of respondent number 7.
No, when did the secretary pass the order?
Secretary passed the order on, my lord, 25/5/2023, my lord,
25.
2023.
And which is the sale deed they are referring to?
That is not still the permission, my lord, subsequently, my lord.
No, the salary is also maintained, but that could
Huh?
not be executed.
Prepared but not executed.
Prepared, but could not be executed because of this Honorable High Court's order.
So you mean to say from 195, now there is a new patta 241?
Yes, my lord.
No. But actually my learned friend is, perhaps I do not know, kindly see page 20.
After passing of. the
Page
secretary's
20 of
order.
my IA, here, we have no claim over their land.
Okay.
We have no claim over their land.
Yes.
What, my learned friend is representing Shah Alam Talukdar, Shah Jamal Talukdar. We have no claim on that. Because land is 7 mega 4 katha 12 lesa. In the name of 2%, kindly see page 20. 50% he will get. We have no objection on that.
No. 241, how did 241 come into being?
I do not know because of this order that I felt it could not be executed. And I am a patient. I am a
Your
patient.
patient, you can't help it. You have daughter,
But law
sons,
is-
you
law is
you have
helping
sons
me.
and daughters.
Law is helping a lordship should extend with lawful help. Because 241 is now also not their claim. And now they are
No,
saying.
their plea is
notification-
not 241, but how, where is it anywhere on record that 241 came into being on the basis of
195.
195?
That is not there. That is not there.
And where is the interim order? Interim order only stays that order of the BTC. Then how are you affected?
Not state, only status quo is to be maintained.
Wanted to clarify the matter, but when my learned friend took a very intelligently to another direction, notification. Notification she has
As
not
regards the
challenged.
land in question be maintained till the returnable date. The land in question will be only dark number one, patta number 195.
Right, right.
51 was created after secretary's order, lordship, that has to be clarified.
Bringing till judgment day, they will bring one after another.
Lordship say.
And
which
this
date
court
it
will
prepared.
hear them.
No, no, you claim 241.
Yes.
On what basis?
On what basis, my lord, we are our salaried is there.
No, understood. Show me your sale deed.
Salaried money, gift it.
Which is the gift?
Yes, that I'm showing you. Gift it.
That lordship, Esso's order.
Page
says that
14.
If did it
Of
also
IA.
lordship, not. It is also illegal.
And vernacular is 15. Here, Barabar, Shah Alam Talukdar, Aru Shah Jamal Talukdar.
It's okay, but what is the land?
14. Page 18. So, page 18,
What is the dark number?
that number, here, Abdul Ghani, number, deed number, cell deed number, so and so. That number. Says land measuring 7 bigger, 4 car 12 sir. Dark number. Settlement or X 10 নম্বর খতিয়ানোর, kindly space 17, 10 নম্বর খতিয়ানোর 16 নম্বর দাগর 1 বিঘা 2 কাঠা 11 লেসা 77 নম্বর দাগর 4 কোঠা 4 বিঘা 4 কোঠা 11 লেসা 78 নম্বর দাগর 1 বিঘা
Like you are saying, this page 26 deed is a fake document. See, page
I am
26.
not saying ASO and senior
Understood.
services.
Your contention is 26, that is deed number 1326 of 2020, 2004 is a fake document.
Yes.
When did you come to learn about this document?
No, when we came, immediately we filed petition before ASO, then page 26.
Okay. So after this, their name got mutated out there and they got a patta on the basis of this.
That
You have not challenged this deed.
this deed, no, this effect deed. So we have not challenged it, is their duty.
No. This is your duty. Your land has been taken away by a fake deed.
And it is in my favor.
Hello.
It is against them.
We will not
But
trouble you.
clarified,
We on the basis of this aspect only we dismiss it, allow the petition. This deed having not been challenged by you, obviously the title will always flow upon them, irrespective of anything. The
No,
patta has been issued to them. Why king is there? Where is your document to show that 241 came from here?
241 is totally different.
So if it is 241, all these documents shows 241.
Yes.
Then, and what is this page 42 is a what document? In favor of Shah Alam and Mahmud Ali. Shah Alam Talukdar is who?
Wants to sell to Mahmud Ali's, deed is prepared, lordship, after the impugn orders.
Oh, he has taken the money. But this is the different document.
This is yet to be executed, only prepared, lordship.
This is patta number 241
Lordship.
and 77 and 345. Yeah, where is 77? Dark number 340 new. 77 comes from where? Different.
From 195 patta, lordship.
Part of that patta.
You cannot challenge this order. You even can't challenge, or neither the BTC secretary or anybody cannot touch it unless and until this document is set aside. And there's a patta. Matter over. What to
There is
do?
a patta,
Should
that
I
patta
dispose
is
of the
not-
IA?
That patta
dismissing
is
your
not on
IA?
record.
I dismiss your IA now. So that you can go to the division bench.
No, lordship may only dismiss the whole, dismiss or allow the whole writ petition.
No. I can't, because there is the important question involved. You wanted a vacation of the order.
Question has been raised by my learned friend, that is, which is not in her prayer.
What prayer is required?
Prayer is required because it's challenging a notification.
Mr. Mahmood, I think it is too much. You are a senior,
No.
senior,
My lord,
you have
notification challenged in a
got a lot of
proper manner.
practice. Don't make that submission.
No, my lord. Notification
Then
has
it-
to be
I may,
challenged in
I
a
may
proper
feel
manner.
ashamed of recording that submission.
No. Notification has to be.
Why
challenged.
the notification has to be challenged? There's no requirement. Even the notification does not say that the order of the settlement officer. It only says that that person, the TC, will become the director. And from the director of land revenue, it said about the BTC secretary. But the power has not been given from the ASO or the SO to the BTC secretary. Unless it is not given, that is a vacuum.
Here
The
are-
only way is that the Assam Board of Revenue, Assam Land and Revenue Regulations will hold
My
it.
submission is here, two parties are fighting for a plot of land. Now, how
That I
the
will consider
notification come?
later on. That aspect I will consider later. Let me first vacate, dismiss your petition. You wanted yet that day that I should dismiss. That day I did not. But today I think I'll dismiss your petition.
But patta is not on record.
Huh?
Patta is not on record.
Anyway, she has given it. I'll put it on as X. Don't worry. Because that is already mentioned. This is not for the first time. The ASO order categorically mentions, and it is on the basis of this patta it has happened. You have not sought for cancellation of the patta.
Who knows?
The little bit I know about the land and revenue regulations, whenever a patta has been written, rightly or
That
wrongly,
we did
you
not have
have
any
to
idea.
challenge the patta.
We have not come
And the
to
patta cannot be challenged in a civil court. It has to be cancelled before the revenue
the
court.
revenue authority.
Now the revenue authority, when the AE is a patta, the BTC or secretary or whoever it is, they cannot do unless the patta is challenged. Because this is a document of title, irrespective of the sale.
Patta is a document that there is no doubt. But thing is, it is on record. I got no chance to defend, to reply about this.
So you want an adjournment today?
I mean, let them come with affidavit.
Huh?
Let them come with affidavit, then only I will be able to answer.
You expressed urgency in the matter.
Urgency that 241 is not here.
241, you show it how 241 came into being. Where is your document of 241?
That can be shown by the revenue authority.
No, you say you have put it out there in the sale deed about 241.
Yes.
Else all along it is 195. Where does 241 come in?
241 is written by BTC authority.
Where?
Yes,
Where?
I'm showing you. Yes. Can you see verse 41?
Of your IA?
It is Under Secretary Revenue, Bodoland Territorial Council. So they are the custodian of record. How can I say that from
It
here
is the
or there?
circle officer report on the basis of the so and so Iman permitted to transfer Korongiti Iman of Iman land covered by Dag number 339 new 16344 old and patta number 241 of Iman. So this is
Permission, Lordship. This is
this is the permission being given.
Yes, permission given by
This permission has to be based on an application.
My lord, read court should not go here and there to frustrate the cause of justice. There are so many citations. Simple question is this, it is mentioned by BTC. And BTC is the proper custodian of record. I am not the custodian. So the court should say that you clarify this position, that is not my duty. It is the duty of the revenue authority of in BTC. Now BTC has recorded, court should believe this. And if they disbelieve this, they should go, they should challenge. That is my humble understanding.
That, however, is not the understanding of this court. That is the problem.
But it is a court of record, my lord. It is a court of record. What order will be passed today, 100 years, it will be researched. That
About this,
a
but
third
I
person
have already
came
mentioned, Lordship,
and
page
filed petition.
No, how did you get the permission? This is the, no, Mr. Mahmood.
I have
Mr.
been-
Mahmood, first of all, you see, I may be sitting in a bench 5 today, a read bench, but technically I have done bench 1 matters.
Yes.
So being a bench 1 judge also, I know that you cannot get a permission unless you file an application. In the application, you must have mentioned which is the dog you are going to sell and the patta number. Are we supposed to understand that you asked for some other dog of 195 and not here without knowing that you have asked for 241 without knowing that the 241 has come from where? Tell me.
When the,
This is the basic question.
these types of question cannot be answered by BTC.
BTC, I will ask. Don't worry with the BTC. I will ask the BTC. But first, you answer that.
Then in my petition, I think petition is there. Petition is there. I remember party came one day and have.
So what do I do, Mr. Mahmood? Should I dismiss your IA or keep it
No,
pending?
you have every right to dismiss.
No, should
And I
keep
have
the-
every
No,
right. to
then
do
only
so.
you can go to division bench. That day you said.
That, what that lordship's.
You go for that, for vacating, but let me give orders now. That day I didn't have the time. Or should I pass the order in the main writ petition?
I think
Or Mr.
This is- this is my
R.
petition.
Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. S.R. Rava, the learned counsel appears
Lordship.
on behalf of the BTC. And Mr. M.U. Mahmood, the learned counsel appears on behalf of the private respondents. Number 7. And Mr. So-and-so appears, H.R. Emmett appears on behalf of the respondent numbers 8A2, 8A. Good stop. This is your application for setting aside the, not for permission.
This was the petition filed. And
This is an application for setting aside the done in, and as such, it became miss case number 3 of 2022. So, anyway,
কিন্তু সেটার বিষয়ে রহস্যজনক কারণ অবৈধ দলিল যুগে রেকর্ডভুক্ত হওয়া ব্যক্তিসকলের নাম কর্তনত অনীহা প্রকাশ করে প্রমাণ অপেক্ষা সংশ্লিষ্ট নথিপত্র অভিযোগ
this court, by an order dated 7/8/2024, raised the question
or IA.
as regards the authority of the BTC secretary to take to decide an appeal on the basis of appeal against an order of the settlement officer. In view of the provisions of section 147B of the Assam Land and Revenue Regulation 1886. This court further inquired with the learned counsel appearing on behalf of the BTC as to whether the notification dated 30/12/2016 can override the provision of section 147B of the Assam Land and Revenue Regulation 1886. Full stop. And thereby, full stop. This court thereupon fixed the matter on 19/8/2024. On the same day, an instruction was placed before this court, issued by the Joint Secretary of the Bodoland Territorial Council, wherein it was stated that the BTC had not intervened with the authority to whom the appeal lies under section 147 of the Assam Land and Revenue Regulation 1886. However, the appellate authority should be, it was also stated that the appellate authority should be the Assam Board of Revenue as per section 147. Be that as it may, it was also stated that by virtue of the notification dated 30/12/2016, the BTC being a tribal area, an autonomous council and its administration is run by the provisions of the 6th schedule of the Constitution. The BTC authority ought to be the appellate authority at first in the BTC area. It was also mentioned that the decision passed by the Secretary of the Department, if agreed, may be appealed before the Assam Board of Revenue. In view of the said instructions so produced before this court, this court inquired with the learned counsel appearing on behalf of the BTC as to whether the same would not amount to amending the Act of Assam Land and amending section 147 of the Assam Land and Revenue Regulations 1886. Under such circumstances, the learned counsel, therefore, appearing for the BTC, therefore sought for further instructions. Today, when the matter has been taken up, Mr. S.R. Raba, the learned counsel appearing on behalf of the BTC, submitted that the Advocate General of Assam had been entrusted by the BTC to look into the said matter and as such had sought for 7 days' time to apprise this court on the instructions. He further submitted that as any order passed on this issue would have wide-scale ramifications, this court may hear the Advocate General before passing any order. On the other hand, this court have also taken note of the issue involved in the instant proceedings, taking into account that the learned counsel appearing on behalf of the respondent number 7 had insisted that the interim order so passed by this court on 13/10/2023 be vacated. From the materials on record, it is seen that the assistant settlement officer, by an order dated 24 pre-2021 have granted mutation to the petitioner's hearing in respect to a plot of land measuring 4 katha, 15 lechas, covered by dark number 69/16, along with the respondent number 7 and the predecessor in interest of respondent number 8. Your name is what? Saha Jamal. This order was challenged before the assistant settlement officer by filing an interlocutory application by the respondent number 7, which was registered and numbered as Miss Case number 7/2022, or 3/2022. While the same proceedings were going on, the petitioners herein moved the settlement officer by filing an application being Miss Case number 2/2022, stating inter alia that the assistant settlement officer has no authority to decide on the application, decide the application which have been registered as Miss Case number 3/2022. And as such requested that the Miss Case number 3/2022 be stayed and and for the reliefs and further sought for other reliefs. To the said application so filed by the petitioners before the settlement officer, the respondent number 7 filed its objection, his objection. The settlement officer thereupon passed an order on 27/2022, whereby, taking into account that the patta has been issued, being patta number 195, in favor of the petitioners as well as the respondent number 7 and 8, the settlement officer maintained the order dated 24/3/2021 passed by the assistant settlement officer. It is, however, relevant to mention that in the order dated 21/7/2022, the settlement officer duly had taken into account that there are allegations that the documents of sale were forged. But the settlement officer did not go into the said aspect of the matter, taking into account that the patta has already been issued. Be it as it may, an appeal was filed by the respondent number 7 before the Borough Territorial, before the Secretary, PTC, wherein the impugned order dated 25/5/2023 has been passed. The challenge made in the instant writ petition relates to are primarily on two grounds. First, that the BTC secretary had no authority to decide the said appeal, and it ought to have been an appeal filed under the Assam Board of Revenue before the Assam Board of Revenue in terms with section 147 of the Assam Land and Revenue Regulation 1886. Secondly, it was challenged that the said order was passed in violation of the principles of natural justice, inasmuch as no notice was issued to the petitioner before passing the said order.
Appellant number 2, Shahjamal Talukdar was dead at that point of time. Appellant, respondent number 7, along with predecessor of respondent number 8A to D, preferred the appeal, Lordship, as per page 32, Your Lordship.
Both were there.
Appellant number 2, Lordship, at that time, 25/5/2023, is already a dead person.
But that we have given the petition, there is no signature of Shah Jamal. It is wrongly written. I have given the copy to you.
Taking into account the facts and the jurisdictional issue involved as to whether the BTC secretary could have at all decided the appeal. This court is of the opinion that the interim order passed on 13/10/2023, thereby directing the parties to maintain status quo of the land in question, requires to be maintained till further orders so to be passed by this court. Accordingly, this court fixes the matter on when? 12 September. I have not sought for the Advocate General's assistance. Be careful. When I seek, I will wait. If I don't seek, it is his duty to appear. So don't ask me time on the next date on behalf of the Advocate General. Huh? Now give me. Well, list the matter again on 12th of September 2024 at the top of the list. Pusto. The status quo order so passed earlier in respect to the land in question shall be maintained till the next date. Pusto. The respondent, BTC, shall further apprise this court as to whether there was any partition to patta number 195, which is the patta in question, pursuant to the order dated 25/5/2023 by the Secretary, Land Revenue and DM Department, BTC. In addition to that, the respondent number 7 is granted the liberty to file additional pleadings to show that DAG number 2, patta number 241 is independent of patta number 195.
All for the record of the BTC's records.
So the petitioner is also granted the liberty to bring on record the patta by filing an additional affidavit by the next date.
The petitioner or not then.
On the next date, the records of the proceedings of, what is the number case? Of the impugned order dated 25/5/2023 be produced by the BTC. Because that is produced, I think things will be.
Petition appeal number BTC LR 688/2022. page 32.
Produce.
Every of it.
It's after 226 proceedings.
My lord,
I think we'll condone
Sure.
it. We'll
yes.
see. Interlocutory application code, IA 53 of 2000, 53 AP of 2024. This is an application filed for condoning the delay of 648 days in filing the review petition against the judgment and order dated 23/5/2022 passed by this court in WPC number 597 AP/2018. Full stop. From a perusal of the said petition, it reveals that that pursuant to the order passed by the judgment passed by this court on 23/5/2022 in WPC number 597 AP/2018, an appeal was prepared, which was registered and numbered as writ appeal number 14/2022. Full stop. The said appeal, however, was disposed of by an order dated 19/3/2024. Full stop. While disposing of the said appeal, there were certain submissions made which were not placed before this court, before this court, when the writ petition was being adjudicated upon. And accordingly, the writ appeal was disposed of on withdrawal, granting liberty to the petitioner herein to prepare an application, to prepare a review application along with an application for condonation of delay. It is under such circumstances that the instant application had been filed. This court also duly takes note of the reasons which have been assigned in the said application, and the same, and also have heard the learned counsel appearing on behalf of the petitioner, as well as the respondents, including the private respondent. Full stop. The grounds so assigned in the instant application, in the opinion of this court, constitutes a sufficient cause for condoning the delay, and accordingly, the delay of 648 days in filing the review application is condoned. Full stop. I stands disposed. The raised full stop. Yes, now in the review petition, you will file Mr. Panging, you file objection?
Yes, I would like to, because even the writ petition is not enforced with the review petition. And I had filed 2 objections in the writ appeal because new grounds were raised. So that is also not filed along with the review petition.
Now, I will issue notice then.
My lord.
Where is the application? Who appears for the government? Anybody there?
Government is not present, my lord, today. Mr. Tapin used to appear.
Huh?
Mr. Tapin, senior government. I will inform him.
Yes. We issue notice.
My lord.
Issue notice. A review petition. Issue notice returnable on how much time for filing?
My lord, at least 3 weeks, my lord.
Okay. Issue notice making it returnable on 23rd of September 2024. Full stop. Mr. D. Pangi appears on behalf of the respondent number
1.
respondent number 1. Full stop. Mr. Kapil, what is his name?
Tapin.
Mr. S. Tapin, my lord.
Yes, Kapil, appears on behalf of the learned government advocate, appears on behalf of the respondent number 326. Full stop. Taking into account that the respondents are duly represented. Extra copies of the review petition be served upon them during the course of the day. Full stop. On the returnable day, on or before the returnable day, the respondents shall file their response.
My lord.
All right.
Okay.
Item 22 for motion.
Happy Lordship. Lordship, the petitioner is running a small man shop. Now GMC in assistance the Appellate party now trying to dismantle my lord. Lordship, just look for one page 33. Page 33, man.
Page?
33. My lord, this notice has been issued by Assistant Town Planner, my lord. Now, my lord, he deserves no any authority, my lord. A similar issue or identical issue already dealt with by this honorable court, Lordship. My lord, that has been taken care of.
Who has no authority?
My lord, Assistant Town Planner,
Page 36.
33, my lord, 33.
What are you challenging?
My lord, I'm telling this much, and this is the consequential effect is place 38, my lord, where my lord, a notice has been issued under section 337(1)(2) for demolition.
Are you not challenging 38? Then?
But this is second ground, my lord. Even my lord, this notice cannot be issued by virtue of my lord without invoking a separate part, my lord. Because lordship can see this notice has been issued, page 38 for a moment, my lord.
Yes.
Under section 337(1) and 2, that cannot be, my lord.
Huh?
That cannot be, my lord.
What?
But it should be 337(1) first, supposed by the commissioner, and thereafter, my lord, being dissatisfied, then 2 will come, and finally, my lord, action in 3, my lord. There is the contemplation of 337. But anyway, my lord, so far the initiation of proceeding, that is page 33, my lord, itself shows, my lord, the matter is under consideration before this honorable court, that whether he deserves this authority or not, my lord. Because if he deserves no authority, my lord, question doesn't arise, my lord, further proceeding null and void, my lord. And this is the order, my lord, I have placed. But 37, my lord, GMC disallow the delegation of power.
But first of all, who are you?
My lord, yes. But I am the person who purchased the land, my lord. Now, person to purchase of land, no, my lord, my construction agent today unauthorized, my lord. There is no need doubt to that effect. But my lord, for the purpose of regulation, in the month of December, I have applied before the GMC authority.
For?
GMC authority for regulation of my construction. Now that is pending there, my lord. They will
No, you didn't take a permission.
My lord, yes, my lord. Because my lord, I have carried out the construction, no doubt, my lord, without permission. This is true, my lord.
Eh?
My lord,
Make
question
it-
is that my there is a
You have
provision.
demolished.
My lord,
I gave you
absolutely, my
authority.
lord. Lordship.
I'm asking you for
Lordship,
the.
kindly for a moment, my lord. Lordship, it is a matter of regulation, my lord.
No
My lord,
regularization,
yes,
no
my lord, provision
permission.
is there, my lord. Can you see, my lord? I
This is
can
the
regularize,
NOC,
my
my
lord.
lord, not the building. He is not even in the building. He is
Ah.
constructed the shop in the setback of the building. Not even in the building. It is
No, not
and
my. It is not
it
a
is the
kind-
residential. It is the residential NOC. And they, I mean, he wants to run a shop.
Anyway, my lord, let them take a call on my lord. My lord, can you see regulation is a
Let
part
them
of.
take a call, go there, they will take a call.
Absolutely, my application is pending, and so far, lordship, can you see this is the position appendix 3 clearly say in case of even illegal construction, a person can apply, and that will be tested in the light of building bylaws, and thereafter if entitled, that will be regularized, and not that would be directed to be demolished, my lord.
But is a building with, if a construction is not made in accordance with the provisions,
My lord, the permission we have.
no, without the permission, where's the permission?
I have
Show
only
me.
that one.
No, this is the permission.
Exactly, my
Yes,
lord.
where's the
Now,
permission?
my lord, so far my.
No, where's the permission for construction? It's a residential zone.
My lord, I am the part, my lord, which is apart from that, my lord, NOC. Now, so far, my
You
NOC, my lord,
cannot.
that I have applied for. But lordship, kindly see, so far, their initiation of action is suppose affected by law of limit, my lord, by law itself, my lord. How it can be, my lord, they can contemplate, my lord, kindly see. 37, my lord, section 37 GMC Act, disallowed them to decentralize the power to, my lord, subordinate officer. But
Forget about 37
Anyway,
and
my lord,
anything.
but-
They, whatever they do. But who are you?
But yes, well, I am the
You
land-
have purchased some land from somewhere
Well,
and then you are making construction without a permission.
just
Nothing.
read for 337.
DMCA conduct. Show me the bylaws which say so.
337.
Regularization.
Yes, my lord, this one.
We can apply.
My lord, in Guwahati.
Have you applied for regulation? Where's your
That
application?
application lying with them, my lord,
Okay,
GMC authority.
You don't have it.
My lord, copy I don't have, my lord, but let them make a clarification that I don't have, my lord, copy.
Not necessary.
18(1), modification of plan.
It is not a case of illegal, it is a case of irrelevation, my lord. It is compoundable, my lord.
Oh, this is
And my land suits, my lord, otherwise also. Small shop within 5 acres land. my lord.
How can you go for compounding
My
of
lord,
a use of the building?
My lord, so far building is concerned, my lord, this is separate, which is the permission there, and my land is separate, my lord.
Hmm.
Out of which, my lord, to regularize my construction, I have applied for.
Ah.
Now, in the light of this, my lord, bylaws, it is possible to regularize or not regularize, there must be a decision on that effect. Now, lordship, kindly see their contemplation, which is very important, my lord.
Hmm.
337 for a moment.
Huh?
337 GMC Act, otherwise demands that a notice has to be issued to the owner, my lord. Just read for a moment, my lord. 337 GMC Act. Here, my lord, if any building is erected or re-erected in contraventions of any development scheme mentioned under 322 or any building bylaws made under section 416 or without plan having been deposited or notwithstanding the rejection of plan or otherwise then in accordance with any requirement subject to which the commissioner pass the plan, the commissioner may, without prejudice to his right of his taking proceeding in a court of law for such contents by notice to the owner, clearly mentioned to the owner, either require him to pull down or remove the work, or if he should elect to effect the alteration therein as may be necessary. But there is a clear contemplation that owner is entitled to get notice. And I have intimated them in the month of March, even in the month of April, by way of reply.
No, where is your any document which have been mentioned that you have applied for?
My lord, yes, my lord.
Hearing.
That crisis
You
was a while, my lord.
purchased a plot of land.
Yes,
And then thereupon you are constructing,
yes, my lord. Question is
whether
that
it would be in violation of the FAR.
so far, my lord, my construction is concerned.
You cannot construct anything.
Absolutely, quite right, my lord,
Yes,
quite right.
then-
Sir. But since this contemplation of the bylaws clearly says I can apply for regulation.
There is no regularization there.
Let them take a call on my lord, they will clarify that because.
Your application is not
My
here
lord, we are
before
also
this
trying,
court.
my lord, because,
Not
my lord,
Did you, did you approach the authority?
Yes, yes, my lord, because my lord, today itself we have approached the authority, lord.
Go approach.
2 or 3 days, my lord.
Where is your application at all?
My lord,
Asking for that.
my client only, my lord, one thing he has
You
missed out
will-
that he could not, my lord, keep the records, my lord. But today itself he is approached before the authority to get the copy of, my lord. We'll place it, my lord.
Lordship will turn to the building bylaws of 2006, page number 333 of the book. 333. No, 333. Well, that. I can
Okay,
open.
building bylaws.
Building, by the appendix 3, there is a provision for compounding. And here is the building is given for residential and it is used as commercial. So use of building is a non-compoundable offense.
Yes, that is what I'm saying.
No, my lord, no, my lord. I make the position, the permission itself, my lord, I think he's not much available.
Permission categorically
Permission,
says
my lord,
residential.
My lord, I have the commercial space also. This is the diagram, my lord. 6 shops are there, my lord. This permission itself says, and apart from the site plan, clearly indicates commercial plus, my lord, residential. 6 shops are in.
Where is the permission given? Approved
Permission-
plan. Show me the approved
yes.
plan. The permission here is only for residential.
Residential.
My lord, residential given, but my lord, residential building, but afterward, my lord, this site plan approved by them.
Show me the approved plan.
Yes.
Permission is later after the approved plan.
And I am
Maybe-
even not concerned with the soap otherwise. What is these are the soap? It's just a case of, my lord, rivaling, nothing more, my lord. GMC just jump into it.
Giving permission constructing.
My lord, my learned friend even appear to the power issue. Left hand, my lord.
Where is the approved plan?
This is the approved plan, my lord.
Where is it?
My lord, soaps are there. 5 soaps are there.
This is not the approved plan. Approved plan always has an approved
Seal
signature.
is there, my lord. Seal is there, my lord.
Where? No seal. The seal is of Datta and Associates.
My lord, GMC is also there, my lord. See on the top.
Still approved. Then at that particular point of time, there was a committee hired as committee.
Question is that, my lord, I am simply holding a land. I have applied for regulation.
Without permission, we should not have
Absolutely, my lord, but-
constructed.
my lord, Well, kindly see this is. GMC only. Everything we would like to bring on record. My question is that only 4 days holidays disturb us, my lord. We have prepared diagram also, my lord, to clarify the entire position. Everything you would like to bring on record, my lord.
Where is the shop?
Shops are there, my lord. Left side or top?
Huh?
The bottom side. Left. 5 shops are there, but 6 shops. It's a small shop, my lord. Why they are, my lord, want to make me? If somebody put a complaint, my lord, now they are running after us, my lord. They are not running against the building, my lord.
Is your building shop made within the building?
No, no.
It is apart land.
Where is the shop here?
Well-
Show me. Outside the building.
Yes.
Outside the building, the setback area. Outside the building, in the setback area.
Where? Show me where the shop
Okay.
is there.
Well, my land is here, my lord.
Your land may be there, but your land, I'm not on that. 4.86 lectures covered by dark number so and so. Where is that shop? Show me. Outside the building.
This one.
I have even checked, my lord. I have even checked in the net, that particular apartment. There is a 3D full picture that clearly shows that the building is there, shop is in the left hand side,
Yes, ma'am.
outside the building.
Outside the building, there is no
Outside the
permission.
Well, outside the building, well, a land was sold to me against
Yes,
it
outside the-
independently.
Where?
But I have marked, my lord, black mark, my lord. That is just tree. There is a tree, my lord. That outside of the building, my lord.
And how can you do that?
Exactly, my lord. Question is that, my lord, I have purchased this land.
Permission is
Well-
given.
My lord, independently, I have purchased the land, and after
Right.
purchasing the land, my lord, I have applied for regulation. Now, after regulation, they have to take a call, my lord, whether I am entitled or not. And second aspect of the matter, lordship kindly see that the power which they have exercised, which is
You
otherwise.
have applied for regularization. This permission has nothing. It is a separate land which have been sold to you.
Yes, ma'am.
And this land which have been sold to you, you are constructing outside the periphery.
Yeah,
of-
exactly, ma'am. Quite right.
Exactly. Now you have not. We can do only one thing out here, that the notice should have been issued to you.
Yes, ma'am. Yes. That is the entire, that's why my picture, let the picture be cleared, ma'am.
To dispose it. You
They have to,
are
but let them take a
Take
call.
action by issuing notice under 337.
Yes, ma'am. No problem.
To the petitioner. He himself says that he is the owner.
He says that he is the owner. Because here the notices have been
To
issued.
the
to the
building.
apartment.
That I have seen, that I have seen.
And from that document, it is seen that this is nothing to do with that.
No. He do.
The apartment, it is the building is, the construction is outside the building.
Exactly.
Construction is on the setback of the building.
So
Not on-
therefore, on the setback of the
Of the
building, you can also take action against Tilutoma apartment. That is one.
To the builder, to entire builder who has constructed
But
it.
what has happened is, the builder has sold the land to him.
Builder
What
has
is
sold
it
the
about-
land, only the land to, because the reply is that there was an agreement between the builder and the petitioner that there will be 6 shops. Ultimately, that 6 shop doesn't come up. So he sold the land to the petitioner.
No, madam, that is
But
not a
can you
correct
sell
picture.
the land to the petitioner?
No, but there he says that I have an attorney, so I have sold it the land, that land to the petitioner. If lordship goes through the representation before it starts from page number 42 onwards. This is the representation. to the commissioner.
Even after, my lord, they didn't issue us notice, my lord. We brought to their notice everything. At least one
There was a
opportunity
promise by the
given to us.
builder to give him a shop, but it was not given, so land was sold to him.
The substantial justice demands, my lord, that we have to say our say. Clearly mentioned, my lord, despite of that, my lord, they didn't issue any notice, my lord.
Second line itself says shop is in the front side of the building.
D37, even itself demanded owner must entitled to get notice.
You cannot construct without a permission.
Absolutely, my lord. Let them take a call, my lord. We'll justify our cause, my lord.
When they,
Let them issue us a notice, my lord. We'll reply.
Lord,
or Mr. Samaria, the learned counsel appearing on behalf of the petitioner. The so appears on, Mr. Esbora appears on behalf of the respondent numbers 1 to 5. Taking into account the youth involved in the instant proceedings. 4. Plan to dispose of the instant repetition at the motion stage. Further to that, in view of the dispute, the questions involved, this court does not find it relevant to issue notice upon the respondent number 6 and 7. From the materials on record, it is seen that the performer respondent number 7 had by the deed of sale bearing deed number 28, bearing deed number 13352 dated 28/12/2020, sold the plot of land measuring 4.86 lectures covered by dark number 2396 new of KP Patta number 860 new, situated at Revenue Village Sohor Patasil under Moza Beltola within Revenue Circle Dispur in the district of Kamrup Metro, Assam. Pursuant to the said sale, it transpires that the petitioner constructed a what have you constructed?
Commercial shop, my lord. Commercial shop.
A commercial shop on the said land, which have been assessed by the Guwahati Municipal Corporation as holding number 12559420 of ward number 6. Full stop. It further appears that on 8/1/2024, the Assistant Town Planner, Guwahati Municipal Corporation, issued a document to the, issued a notice to the Tilutwanwa apartment along with the performer respondent number 7 in pursuance to a letter received from one Ashok Sharma, the respondent number 6, alleging illegal construction of building. The performer respondent number 7 thereupon issued a communication reply to the said notice on 19/1/2024, stating inter alia that after completion of the building, he had handed over the building to the Tilutpama Apartment Residential Society and Tilutpama Apartment Commercial Society, along with the no objection certificate and the approved plan of the building to the Tilutpama Apartment Residential Society. It was also mentioned that if the office of the GMC found that the construction of the building illegal and extremely deviated from the approved plan provided by the GMC, the office shall opt for demolition of the deviated parts of the apartment if it deemed fit. It was, however, stated that if there is a provision to pay a penalty and regularize the deviated part of the apartment, the performer respondent number 7 be informed about the same, so that the residents of the residential part of the apartment as well as the owners of the commercial shops of the apartment do not have to suffer any kind of loss on their part. Subsequent thereto, the commissioner GMC has issued a communication on 6/4/2024 to both the Tilutpama apartment as well as the performer respondent number 7. Stating inter alia that the notice was issued for documents on 9/1/2024, but in response to the notice, notes reply have been submitted. And as such, notice under section 337(1) and 2 is now being prepared. It was further mentioned in the said notice that if there is no valid explanation as demanded, and the explanation so submitted is unsatisfactory, authority would be free to proceed under section 337(3) and 337(a) capital A bracket 1 of the GMC Act of 1971 to demolish or seal the unauthorized construction as mentioned in the schedule. It is very pertinent to take note of the shop which was mentioned. The unauthorized construction which was mentioned. The said shop is a shop in front of the building and not within the building where the permission was granted. To the said notice, the performer respondent number 7 issued a communication that the said shop was constructed not beyond the approved 6 number of shops in the approved plan. But admitted that there was deviation in realignment of the shade shop, which may be compassionately viewed by imposing a penalty as provided under law. Inasmuch as the innocent shopkeeper owner, that is the petitioner herein, had purchased the shop for consideration and would suffer irreparable loss for no fault of its own. It is also seen that the petitioner thereupon had also submitted an application, the representation on 21/8/2024. The case made out in the said representation dated 21/8/2024 is that the owner of the shop was never put to notice. And on the other hand, on 28/2024, personnel from the GMC enforcement branch came for demolition of the shop of the undersigned of the petitioner without following due process of law and without giving him any opportunity of hearing. It was also stated that on the resistance and objection made by the son of the petitioner, that no notice had been issued to the owner of the shop as regards deviation of construction, the GMC authorities returned back full stop. It is under such circumstances the petitioner requested for an opportunity of being heard by serving notice before any further action is taken against the owner of the occupier of the shop until granting full opportunity of hearing. Requested to keep in abeyance the notice dated 26/4/2024. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, duly submitted that the constructions were made was admittedly without any permission being taken. However, to exercise the power for demolition under section 337, the notice has to be issued to the owner. And in the instant case, as the notice has not been issued, it amounts to violation of the principles of natural justice. It amounts not only to the violation of the principles of natural justice, but also an infraction to subsection 1 of section 337 of the Guwahati Municipal Corporation Act 1971, for short, the Act of 1971. In that regard, the learned counsel has also drawn reference to have also placed before this court the approved plan as well as the permission. So granted by the GMC to the respondent number 7. Perform respondent number 7 for construction of the building. He further submitted that in the approved plan, there are 6 shops within the building to be constructed. However, only 5 shops were made, and as such, made, and taking into account the flat owner's interest, a portion of the land was sold to the petitioner by the registered deed of sale dated 28/12/2020. And thereupon, the petitioner had made the construction. He also submitted that as per the building bylaws, as per the Guwahati Building Construction Regulation Bylaws 2014, unauthorized construction, which is within the norms of the building bylaw, subject to the satisfaction of the authority, is compoundable, and therefore submits that the petitioner have also submitted an application to the respondent authorities for compounding the same, which have not yet been decided. On the other hand, per contra, Mr. Espora, the learned counsel appearing on behalf of the respondent, submitted that the construction which have been carried out by the petitioner is in the setback area, which could not have been constructed even if the respondent number 7 have sold that portion of the land. It would amount to violation of the building permission itself. He further submitted.
Which is for residential purpose.
That I'm going. He further submitted that a perusal of the permission would show that the permission have been given only for residential purpose. And even if it is assumed, it is taken into account that the state shop so constructed by the petitioner is in lieu of the 6 shops which were approved by the authorities, then also a commercial building cannot be constructed. Where have you mentioned that you have asked for regularization?
Nothing is there in the petition. This is a subsequent event. There's nothing in the petition.
There I have
Submitted that though the learned counsel appearing on behalf of the petitioner had submitted that the petitioner had submitted for regularization, but there is not a single mention in his pleadings. He further submitted that there is also no instructions that the petitioner have applied for regularization. On the basis of the above submissions, this court have given their anxious consideration. This court, upon hearing the learned counsels appearing on behalf of the parties, and have heard the learned counsels appearing on behalf of the parties and also duly given and due consideration to the respective submissions. From a perusal of the deed of sale bearing deed number 13352 dated 28/12/2020, it is only seen that the performer respondent number 7 have only sold a plot of land at measuring 4.86 lechas to the petitioner. Admittedly, the petitioner, without taking any permission, have constructed the said building, said commercial establishment. Be that as it may, as it is an admitted fact by the petitioner herein that he had constructed and from a perusal of the documents, it is seen that neither the Tilutoma apartment or the performer respondent number 7 have claimed ownership over the said shop. It has to be therefore deemed that the petitioner is the owner of the shop. In that view of the matter, if this court duly takes note of subsection 1 of section 337 of the Act of 1971, the notice has to be issued to the owner. However, admittedly, there is no notice to the petitioner. And as such, any action taken by exercising powers under 337 of the Act of 1971 without notice to the owner would be an infraction to the provisions of Section 337 of the Act of 1971. Accordingly, this court therefore disposes of the incident with petition, thereby directing the respondent authorities, more particularly the Commissioner GMC, to take due action in accordance with the provisions of Section 337 of the Act of 1971 by issuing and 37 of the year, and in that process, and while doing so, shall issue a notice to the petitioner seeking the reply and send a notice to the petitioner. The petitioner, upon receipt of the said notice, would be at liberty to submit the reply. This court, however, has not opined anything as regards how the power under Section 337 is to be exercised by the GMC, Commissioner GMC. It shall be absolutely within the wisdom of the state authority.
Reply and hearing. Only add one reply and hearing, my lord.
What hearing? No hearing. You did that. As of now, this is the case of what is that? Case of useless formality. Principles of useless formality duly applied.
My lord,
7 days notice, then demolition. This needs
my lord,
to
we'll be on the street, my lord.
street. You know it, if you are in.
My lord,
street,
let them, my lord, only one objection is speaking order. My lord, otherwise, my lord, suppose they will come and say that we will not accept your reply, my lord, that become more troublesome.
What?
Speaking order, my lord.
Speaking order is already there. It is an admitted fact.
Anyway,
Now they know what to do. Now they will issue a notice to you. Because there are many mandates. No, after that, what is to be
now,
done?
my lord, now we will handle my lord situation. Now we will handle the situation.
I know what is done.
For admission.
Yes, what is this?
Yes, my lord, this is regarding application of two guideline, my lord. Uh,
What?
As per one guideline, my lord, it was 100 meter. My lord, this is construction regarding outer limit, within the outer limit of army station, my lord.
Where is the notice?
Yes, sir, then, my lord, guideline 50, page 15, my lord, annex of,
I know, don't worry. Where is the notice? Where is the notice?
my lord, notice regarding,
You have been issuing a notice, na? Where is that?
my lord, annex 6, my lord, page 37.
With regard, I have to inform you that in man and on closure two copies of the defense ministry in response to you and has clarified the. What? What are you challenging?
Next page also part of that, my lord, page
Huh?
38 is also.
Then what are you challenging?
I'm challenging that, my lord, as per their guideline, my lord, page 18, my lord, annex 3, my lord. It is, my lord, it was, earlier it was 100 meter. Then, my lord, by the subsequent guideline, my lord, dated 21/10/2016, it was reduced to 10 meters from the outer limit, my lord. And my construction is at 60 meters, my lord.
You fall in party? You fall in party?
Uh,
Do you fall in part A?
oh, my lord, it is a page, my lord.
I know that. Where is
Yes.
it? It's page 21. I'm asking you, does your land fall in part A? But this notification of 21st October 2016 has already been done away with. Yes, madam. Which one?
Yes, ma'am. New guideline has come out, my lord.
Huh?
New guideline has come out,
When?
my lord, 22. Here, my lord. One is defense establishment installation under the management of army where security restrictions shall apply up to 50 meters.
When did this come?
Is, my lord. Kindly see page number 6, my lord, 23rd December 2022.
50 meters.
Yes, ma'am. And for 50 meters, my lord, in page 6 to Roman 2, my lord.
Huh?
Sorry, Roman 1, my lord. The guideline for those who are beyond the 50 meters is, I think, 60 meters.
Yes.
23rd of December 2022.
Yes, my lord.
This is a different one. That day I was looking into another one.
My lord, today I received this one, but this, my lord. In suppression of the above guideline, praise guideline for NOC for the construction and vicinity of the defense establishment are laid down as under, my lord.
Where?
That is page 6, para 2, my lord. Suppression, my lord, in above what are the date of notification, earlier notification, my lord.
When system under the management of army where security reserves shall apply up to 50 meters from the outer wall of searching. Well, Longya is there.
My lord, in two, my lord, one, my lord.
No, this will apply, it's okay, but if in such decision not listed at A.
Listed A,
Whenever the
listed
buildings are of areas 4 stories and above. Will be withdrawn, will not. What is this?
My lord, in list A, my lord, sanctuary is there, my lord.
Huh?
In list A, my lord, page 3, my lord, in column 28,
And this is beyond.
beyond 50 meters is
Then
60
you have no
meters.
problem.
No problem, my lord. Kindly, for that, my lord, they have to, that is in page number 6, para 2, my lord. They have to adopt this new requirement, my lord. This is in place where the local municipal laws required consultation with the station commandant before a building plan is approved. The station commandant may convey its view after seeking approval from the next higher authority, not below the rank of brigadier or equivalent within the 4 months of receipt of the such request or within the specific period. If any required by the law, objection views NOC will be conveyed only to the state government agency or to the municipal authorities and
It's
under.
the same,
Yes,
it's the
ma'am.
same, and then you have this another thing also. You have to first come up with a categorical thing that there is a threat perception. Where is that?
My lord, actually, my lord, the concerned person, the law officer, she is due to some court martial, she is not here, my lord, to.
I have discussed
Like-
many matters of this type.
I see.
You were there. Earlier, you were there. Either of you, both of you.
No, I am not there.
One was the case, these are all cases out here in Guwahati, Khantipur. I have disposed of 2 matters. One was of Mr. Anand Bhuya and the other was of Mr. N. Upadhyay. These
Whether
were the
the-
lawyers.
The number is 7252 of 2000.
Yes. So there, it is the requirement as per the 2023 thing, is the requirement that first you have to kindly see, it should refer the matter immediately to the next higher authority in the chain of command. In case the next higher authority is not also convinced, then the so and so can be. So there is a requirement of a subjective satisfaction that there is a security threat.
Yes.
But there is another one, another provision out there that if it is found that if it is within area also can be done. That is 4D. What is that? That is a different one. Hello?
I'm not. Actually, I got this in the morning, my lord, and law officer is since not here, my lord, she could not brief me, my lord, regarding which one is.
Because you see, something has been changed. Because nowadays you don't have that 150 meters.
Yes, my lord.
Now it is 100 meters. But something like that. 100 meters, is it, no?
In
Okay, we have it some other day then. Because there is one provision, he has not enclosed this. 4B,
yes,
This is
4B,
2000. 4B and 4D.
exception.
This is a 4D notification. Because 2016 has been done away with.
Yes, my lord,
Then
2000.
2016 has been, there is another one which has come in.
But-
2011 has been gone into.
11.
Yes,
my
yes,
lord,
yes.
11 gone, my lord.
Yes, 100 meters, see.
100 meters, 11.
Because now you are reverting to 100, this 18,
Yes, ma'am.
1811, 2011,
Yes.
which is 100 meters.
Yes, ma'am.
But there is another notification in 2023 wherein it says that there is a requirement of looking into it. If you don't find that there is anything, you should not interfere. So you look
So
into
I'll,
that.
yes, my lord.
Yeah.
My lord, some other day I'll go to.
Because this is the same.
No, my lord, this is my lord two
Because,
thousand twenty-two.
this, what you are bringing is a incorrect one. There is a new one. Ms. Again, the learned counsel appearing on behalf of the CBSE submits that he should further place before this court an update on the recent circular so issued. To submit the matter when?
After a week, my lord.
Because I've disposed of 4, 5 matters,
Yes, sir.
2, 3 matters also on 11th of September 2020.
Master bless.
Secondly,
Item 4 and 5.
these matters keeps on 27. Did it?
Please. Chief matter is regarding non-payment of contractors' bill, Lordship.
Bench 4 matter.
Here, my lord, with all respect, my lord, I am seeking some accommodation, my lord. We have to produce the instruction with regard to sanctioning of the amount, my lord. Some part payment has been released, my lord, to the petitioner.
Okay, Mr. Arbopujari appearing on behalf of the respondent revenue department
My lord.
submits that certain part payment have been sanctioned. And in that regard, he would
That is
have
already,
been already paid.
Right.
And as such, he would require to take certain instructions in the matter. List the matter again on 23rd of September 2024.
I'm so obliged.
The respondent shall bring on record their stand by way of an affidavit.
I'm so obliged.
Item 7.
On the last occasion, my lord, we were directed to file the affidavit, my lord. Among 30, my lord, bills from Deputy Commissioner of my lord, 30 district, my lord. 7 were paid, my lord.
Huh?
And I have received, my lord, instruction from 13 district, my lord. There, Sirang and Karimganj, my lord, I have received the instruction that there is no outstanding bills, my lord, now liabilities.
Have you filed your affidavit or not?
My lord, I could not file it, my lord. I have received instruction from 13 districts, but I could not
Okay,
file it. And
Ms. Yudas appearing on behalf of the respondent authority submits that she has received the instructions
from 13 districts, my lord.
from 13
Another
districts
10
out of
districts, out of my lord, 23.
23 districts.
Right.
So she says that further time would be required for obtaining the instructions from the other districts.
Right.
So taking into account that the matter is of the year 2021, this court directs the state to file their affidavit
3 weeks, my lord.
by 38/30/9/2024
Yeah.
without fail. Gusto. List on 3rd of October.
Obliged.
The Monto, we asked you to file some affidavit.
My lord, I have received the instruction. My lord, as per the instruction, it can be closed, my lord. He is correct, my lord. It is as per the instruction I have received, my lord. Just, my lord, for promotion also, my lord, SSLC pass is required.
Huh?
For promotion, SSLC pass required. If required, my lord, I'll file by tomorrow. I'll file, but my lord, instruction will be enough, I think.
Who is appearing for 6?
6, my lord, in spite of the notice, probably he is not appearing, and they just cleared our party.
7 has been appointed, no?
He did, yes, he did. No, there is no stay order also against him. Yes, sir. Ma'am.
This was issued, the High Court's communication was issued when? 13/2/2020. And when was this impugned order passed? 3/3/2022.
Yes, 22, 3rd of March 2020.
Then why? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Burua appears on behalf of the respondent number 1. Mr. 1 and 4.
Yes, ma'am.
And 4.
I'm 2 and 3.
Mr. E.J. Mohanto, the learned senior counsel assisted by so-and-so appears on behalf of the respondent number 2, 3, 5. Pusto. None appears on behalf of the respondent number 6 and 7. The petitioner herein have assailed the office order under memo number DJ dot Roman 12-7/2018/942-56/E dated 3/3/2022. On the ground that the respondent number, where is the document?
Number 6. Respondent number 6. Gradation leaves page 31. Relevant part is page 32, Lordship.
On the ground that the respondent number 6 and 7 on the ground that respondent number 6, your challenge is as to 6 or 7. 6. On the ground that the respondent number 6 who did not have the qualification of having passed HSLC was promoted to the post of, was upgraded to the post of process server Jari Karo against the post vacated by one Sri Ram Kumar Modak, retired on superannuation. First, this court, upon filing of the instant petition, had stayed the impugned order dated 3/3/2022 issued by the district and session judge decree insofar as the upgradation of the respondent number 6 was concerned. Pursuant thereto, though notice was issued to the respondent number 6 and 7, neither the respondent number 6 and 7 chose to appear. Footstep. In the backdrop of the above, the question therefore arises as to whether the respondent number 6 would have been upgraded to the post of process server in view of the fact that the respondent number 6 was only class 8, have passed only standard 8, whereas the petitioner had the qualification of HSLC and was senior to the respondent number 6. Mr. T.J. Mohanto, the learned counsel, senior counsel appearing on behalf of the respondent number 2, 3, 5, submitted that by the notification dated 13/2/2020, this court, in its administrative side, had directed all the appointing authorities of the subordinate court establishments of Assam to uniformly consider the promotion of all eligible grade 4 employees other than process servers to the post of process servers in the light of the draft Assam District Court employees Service Rules 2018 until the rules are notified by the government. He therefore submitted that from a perusal of the eligibility to the post of process server, the process server for for direct recruit candidates, the candidate for direct recruitment, the candidate has to be a graduate in any discipline and must have knowledge in the official language of Assam. Whereas for promotion, the required criteria, educational qualification, is that he must be HSLC passed, and the experience must be that he or she had completed 5 years of continuous service in group D2 of the service. The learned senior counsel therefore submitted that in view of the Assam district, in view of the draft Assam District Employees Service Rules 2018 was required to be followed pursuant to the notification dated 13/2/2020 issued by the register administration of this court. The district and session judge Dhubri could not have passed the impugned order, thereby promoting the petitioner, respondent number 6, thereby upgrading the respondent number 6 to the post of process server jari karo against the post vacated by against the vacant post arising out of superannuation. This court have also taken note of the gradation list of grade 4 staff of the year 2021 of the district and session judge Dhubri. In the said gradation list, the petitioner is at serial number 9, whereas the respondent number 6 is at serial number 13, whereas the respondent number 6 and 7 are at serial number 13 and 14. Against the educational qualification, the petitioner has been shown as HSLC passed, whereas the respondent number 6 is class 8. However, the respondent number 7 is a graduate. It is also seen that the petitioner is senior to the respondent number 6, inasmuch as the petitioner was appointed on 1/2/2007, whereas the respondent number 6 was appointed on 11/3/2013. Taking into account the above aspect of the matter, it is therefore clear that the respondent number 4, it is therefore clear that the impugned order dated 3/3/2022, insofar as the respondent number 6 is concerned, is contrary to the notification dated 13/2/2020, as well as the draft Assam District Court Employees Service Rules 2018, which categorically mandate that for the purpose of promotion, the candidate has to the post of promotion to the post of process server, the candidate has to be HSLC passed. In that view of the matter, the impugned order dated 3/3/2022, insofar as the respondent number 6 is concerned, is interfered with. The district and session judge Dhubri is therefore directed to carry out a fresh election proceedings for filling up the vacant post of the process server in accordance with the draft Assam District Court Employees Service Rules 2018, if not notified till then by the state authorities.
Instruction may be quick part of the document.
The instructions which were placed by Mr. P.J. Mohanto is kept on record and marked with the letter X.
Keep them.
These are specifically marked to me, so.
Obliged, Your Lordship.
Nine.
Yes, what is this? Oh, that matter.
The cinema hall of the petitioner lies at the edge of the ROW, proposed ROW. And in terms of their letter, my lord, NHIDCL, all other similarly situated persons whose building is at the edge of the ROW is sought to be compensated. Now, their contention is, my lords,
That is the government land.
that my building, my lords, the cinema hall, which is standing there from the year 1985, a part of the pillar, my lords, a part of the pillar is in government land, and from that part of the pillar, the rest is my contiguous patta land, my lords. So, my lords, on the last occasions, my lord had observed, my lords, that even in cases where, well, I am not accepting that contention, my lords, that it falls in government land, but nonetheless, my lord had observed that even in cases, my lord, where buildings or crops are there in government land, in case of acquisition, Jirat is paid, my lords. But that is with regard to even if a few inches of the building is in government land. In any case, my lords, I'm entitled because of the letter, my lords. In any case, it is an admitted fact that the ROW is at the edge of the building. That they have admitted in their affidavit that the ROW lies at the edge. And in fact, my lords, there's an judgment authored by my lord, from where it can be seen, my lord, even in cases where there are buildings in government land, my lord, built in government land, Jirat is always paid, my lord. It's not a ratio, but my lord, my lord.
So they, the government only say that they pay.
Yes, ma'am.
You may not pay for the land,
No, man, I'm not seeking for
but
that.
for the building, it has to be paid.
And I'm on parity as well, man. Everyone else is being paid, man. Para 2 and 5, man. According to my lord's order, my lord, we have also filed an affidavit facing the report of the expert. Shows the amount of damage that will be done, my lord. My lord, may peruse two reports, my lord, one by the circle officer and one by the engineer of the PWD. Circle officer's report is at page 28. And
Where is the report?
My lords.
Report?
Report, my lords, the first report by the circle officer at page 28, my lords, of the writ petition.
Huh?
Writ petition, my lords. Page 29 is the vernacular, my lords. May I read the vernacular? Thereafter, there was also a joint survey, my lords. Take. Joint survey is page 35, my lords. This would show the marking, my lords, where it has been marked, the ROW. The second paragraph, my lords. Later on, again a marking showing government land was marked on the building. It is seen that both the marking are in the same level. Moreover, in the joint survey, list of government land is mentioned against the applicant. Any structure in government land owned by an individual is not allowed for valuation without prior permission of the competent authority of the land acquisition. Now, the marking is also there, my lord. If my lord kindly peruses page 26 for a moment, my lord. Where is the marking, my lord? There's a
26.
picture, page 26, my lord. Color picture, my lord. These are the first 7 load bearing pillars, my lord. My lord has seen that red marking, my lord. The pillar to the left is government land according to them, and the pillar to the right is my plot. A few inches, my lord. These are the front
This
7.
pillar means the one with the cross.
One with the cross.
Is
There are
yours.
7 load bearing pillars, my lord, at the same level, my lord. So the middle of the pillar, it has been, the ROW has been marked in the middle. So the left hand side is government land according to them, a few inches, my lord. And from the right, it's my own contiguous plot of land. And page 36 is the letter, my lord, on the strength of which I'm claiming compensation, my lord. And they have also clarified by filing another affidavit that they are paying compensation in terms of that letter to other persons, my lord. Page 36, my lord. Structures lying at the edge of the proposed right. And it is not for the entire building, my lord, only till valuation of structures may be measured from the proposed right of way till the next nearest load bearing wall column.
So you mean to say, even if your land, if the building pillars fall
Yes.
within the government land also, which
Yes.
you don't admit,
Yes.
the first 7 pillars, you say a part of it.
The government also says a part, but they, NI and NHIDCL says the pillars, the entire pillars.
The NHIDCL has no business out here to say.
Yes.
What does the competent authority say?
Competent authority say part of the pillar, my lord, is there. If
We are
my lord
concerned with
take,
the
take up
competent.
the affidavit file by the.
Irrespective of that,
Yes, yes.
Mr. Mondo, why this court should adjudicate this aspect?
No.
Why this court should adjudicate this aspect? Why I'm saying, wouldn't that be a case for proof which has to be looked into?
My lord.
You will be open to raise that dispute. You will be open to raise all these aspects, that how much you are entitled to. These are documents to show that this is the pillar from where the next portion of the pillar you are entitled, how much loss you have suffered. Merely they cannot, the competent authority cannot say that we are not making a valuation. But if they don't make a valuation, you can very well agitate the issue under 3G5.
Yes, my lord, it's not the case of the competent authority that they're ready to pay any compensation at all. They are saying we are not entitled to compensation at all. That is the ground, my lords, and it is.
No.
Yes.
Understood. They may say that it is not. But can you not be aggrieved by that? And then what is the language used in 3G5? Let's read the National Highway Act. And also read 3G3.
A national highway, the right to fair compensation. my lord, I'll read 3G first, my lord.
PG3.
3. Before proceeding to determine the amount under subsection 1 or subsection 2, the competent authority shall give a public notice published in 2 local newspapers, one of which will be in a vernacular language, inviting claims from all persons interested in the land to be acquired. It says the land to be acquired, and that is the reason why perhaps, my lord, the national highway, then my lords, notice such
And there's a
notice.
definition of land.
Yes, land has been defined, my lords. Land includes benefits to arise out of land and things attached to earth also.
So
But my lord,
things, this is things attached to earth also.
yes, yes,
Now, if we go by the definition of Immovable Properties Act,
yes.
or the property as defined in the Transfer
Transfer of
Property Act, that also it will say that anything which is attached to the earth will also come within the ambit of the property.
Right, right.
So under such circumstances, taking into account that the land will also include any apartment thereto. Why you would not be entitled to the compensation? Now, if it is happens, they are to do it. Now, kindly 3G4.
3G4. Such notice shall state the particulars of the land and shall require persons interested in such land to appear in person or by an agent or by a legal practitioner referred to in subsection 2 of section 3C before the competent authority at a time and place to state the nature of their respective interest in such land.
Okay.
I'll read further, my lords.
Hmm.
5. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government. Subject to the provisions of this act, the provisions of the Arbitration and Conciliation Act 1996 shall apply to every arbitration under this act. The competent authority or the arbitrator, while determining the amount under subsection 1 or subsection 5, as the case may be, shall take into consideration the market value of the land on the date of publication of notification under 3A, the damage, if any, sustained by the person interested at the time of taking possession of the land by reason of the severing of such land from other land, the damage, if any, sustained by the person interested at the time of taking possession of the land by reason of the acquisition injuriously affecting his other immovable property in any manner or his earnings, if the consequences of acquisition of land, the person interested is compelled to change his residence or place of business, the reasonable expenses, if any, incidental to such change.
Now, that is one aspect.
Yes.
Now, if you go to section 105 of the right to fair compensation, now what happened? It was earlier, National Highway Act was brought in the fourth schedule for a year, but
Yes.
later on it was been duly applied.
Yes.
Okay. Now, if you see section 29 of this act,
Section 59, my lord.
29.
29, I'm so sorry. Determination of value of things attached to land or building units. I'll read. The collector, in determining the market value of the building and other immovable property or assets attached to the land or building which are to be acquired, use the services of a competent engineer or any other specialist in the relevant field as may be considered necessary by him. The collector, for the purpose of determining the value of trees and plants attached to the land acquired, use the services of experienced person in the field of agriculture, forestry, horticulture, sericulture, or any other field as the case may be considered necessary by him.
Now, in view of section 105(6), you see, 5. 1053 makes that this should not be invalid, shall not apply for 1 year, but thereafter it shall apply. So therefore, the compensation now has to be made in terms with section 106.
Yes,
Okay, and this is also the mandate. So under such circumstances, why, if you are aggrieved, whatever they may say so, you can very well agitate by filing an application, taking an arbitration,
Yes.
because this court, as of now,
Yes.
cannot decide how much it would be.
Right.
But your entitlement to the building
Yes.
or any part thereof, if it is affected, or any land which is appurtenant, can always come within the ambit of it.
my humble opinion, my lord, logic is very correct, but I was not seeking compensation for the land, because it is my contention.
I'm not
itself.
on that.
I'm
I'm not, Mr. Manta,
not-
this court is not on that. The only scope is as to whether the issue arises as to whether a land, if a building falls within the land,
Yes.
even assuming it to be a government, a person would be entitled to the value of the land and building. That's
Yes.
all.
Yes, if that is the, yes,
That is the only thing.
my lord.
Now, if a building falls within even a government land, where you have been enjoying it. Now, see the person interested
Yes. in the-
definition,
my lord, in the National Highways Act or the right to pay.
National Highway Act, because it derives the air from the land acquisition.
Yes. The person interested has not been defined, my lord.
No, no,
Definition, there are only two definitions, my lord, competent authority and land.
it would be another one. National Highway Act says somewhere it is there.
Section 3 is the definition clause.
3C, my lord.
Oh, my lord.
Huh? Somewhere it is there. Person interested somewhere.
Hearing of objection. Where to assess any person interested. Section 3J has also been repealed, my lord.
Hmm?
Section 3J, which says, my lord, the Land Acquisition Act would not apply, that has been repealed by the Supreme Court. my lord. So, right,
3J.
J, my lord, that has been declared to be unconstitutional.
So if it doesn't apply, if it is not here, now, in view of the definition of person interested in right to fair compensation, which is now presently holding the field, a
Yes.
person who even has all persons claiming an interest in compensation to be made on account of the acquisition, the scheduled tribes, a person interested in an easement affecting the land, person having tenancy rights, any person whose primary source of livelihood is likely to be adversely affected. This is person interested. But if you see the earlier act, Land Acquisition Act of 1894,
89.
there also it has been defined includes all persons claiming an interest in the compensation to be made on account of the acquisition of the land, and a person shall be deemed to be interested in the land if he is interested in the easement affecting the land. So your right to remain in possession of a government land, subject to settlement or not, that is another aspect of the matter, but you are entitled to the building, anything said, if you may not be entitled to the land, but you may be very well entitled to the building standing thereon. But the government has not evicted you.
Since 85, I'm doing 1985 building.
40 years. So, but isn't this an aspect which can be taken into account by the tribunal?
These things are at least clarified, Madam, that when, if it is government land, at least for the building, their petitioners are entitled. I'm not on the value, whatever be the value, they would value. That's the beauty of the Kala to value it. And the other part also, my lords, my primary claim, because initially my lords, I was of the opinion, my lords, that maybe the National Highways Act is not applicable for me. So, my lord, my claim was on the basis of the letter, my lord, which was clarified by NHIDCL, that even other people, my lord, irrespective of the fact whether their land has been acquired or not, if their building is situated as at the edge of the ROW, they have been compensated. They have filed an affidavit to their effect. So on that ground also, even assuming, my lords, for a moment that few inches of the pillar is on government land and I'm not entitled for any compensation. Even then, on the strength of the letter of NHIDCL, my lords, I'm entitled for compensation, not for the land, my lords, for the building, my lord, or for the damage caused to the building. Now that how much damage, I'm not on that, my lord. My lords would also not interfere with that because we're not experts, my lord.
But has the PG award been notified?
My lords, what they have stated with regard to the letter, I'll just read it out. They have filed a specific paragraph affidavit, my lord. My lord, give me a moment, that would clarify everything.
Yes, competent authority.
Additional affidavit.
Have you passed the award? Have you determined the compensation?
In terms of the order dated, yes.
The land over which they have been claiming that they need to be compensated, it is not at all their land, it is a government land. So this is the National Highway Authority, this property. So accordingly, even if he is allowed to go for a compensation under 3Z, so it has to be his own land, but here the land.
It has to be?
Huh?
It has to be?
It is not his land. He has failed to prove the fact that the land over which the two pillars
What's
are
the
set.
definition of land? That is why I'm asking you. The land
Things
includes the
standing over it.
also.
Yes.
So if there is any building standing over the land, maybe your land, but the building is his. He has a easementary right. He has been enjoying it. Then wouldn't they come within the ambit of it? He may not be entitled to the compensation for the land, but what about the building? That is the question. he
Things
is
standing
asking.
over that land. Yes. But fact remains that the area of land is not at all being required for the construction, because already that from the photographs also we can make out it is in a passive in the rate petition. Yes.
So are we to understand that you are not going to demolish his building at all, touch his building?
So that is what our stance shows, because
Where is
ultimately
your stand? Where?
paragraph page running page 52.
50?
52.
Paragraph 9.
Paragraph 9.
Anna?
9.
Your affidavit, some affidavit of respondent number
5 and 6, my lord.
5 and 6. 5 and 6 affidavit is where?
The running
It's a running page 52.
52, my lord, para 9.
Para 9.
5.
Part of the pillars.
Five.
Yeah, otherwise, they're saying any damage caused, they are not responsible.
So here, paragraph number 9, you say
Yes.
that the structures standing on that land he is not entitled to compensation
Yes, because of, it is
because it is a
it's
government.
land of the national highway.
Huh?
Of the national highway. And if we go to the next paragraph also, so we have we have gone on to establish the fact that they are the enforcers, in fact, over the national highways land.
So national highway, when it became a national highway?
Because ultimately it is the government land which has been handed
The
over.
substance of acquisition was notified on 20/03/2020.
So only 2020 it became a national highway land.
That's true.
But his building was standing earlier in government land.
1985.
Then why is he not entitled to the compensation for the Zirat?
So previously, what I made to understand is it was the road was under the PWD. So it was the PWD, ultimately the
Very well, PWD very well. He may not be entitled to construction. You have not initiated any proceeding for
proceeding
the
for
Route
demolition.
18.
Yes,
You have not.
no,
But what you have done is you are giving it the land to them.
yes.
Now in that process, there is a building standing on that land. The building which he was enjoying in easement upon. So under such circumstances, why he would not be entitled to the Zirat value of the building? That's all. More particularly, in view of this communication dated,
27/10/20.
where is that page?
36 mileage.
This communication at page 36.
30 additional issue.
First paragraph. Further clarified by the NHI saying that others are giving the compensation, they're in the process of giving the compensation.
Right.
The affidavit dated 25/6/24. That was pursuant to my lord's order. Paragraph 2 and 3, my lord. 25/6/24. Anything they're harping on is, my lord, that few inches of. Paragraph 2, my lord. Paragraph 3, 2 and 3, my lord. 4.
Now kindly come to paragraph number 4. It is further to be stated here that the petitioner's structures is not situated on the acquired right of way. But Mr. Monto, do they anywhere say that part of the 7 pillars in the private land of yours?
Yes, yes, yes.
Where?
The government affidavit, my lord, which my lord has just read, my lord, I'll read it again.
That affidavit of 25-6.
Not 25-6, my lord, the affidavit filed by 5 and 6. The Kala, my lords, para 9. That with regard to the statements in paragraph 8 of the writ petition, the deponent states that the authorities are not inclined to pay compensation to the petitioners as the land upon which part of the pillars have been built is actually government land. That is their stand, my lord. Part of the pillar is government land and the other part is my own. And in fact, NHIDCL, I don't know why they have changed their stand, my lord. In the initial affidavit, they also.
Now then the next line,
Yes.
that the erect of the entire pillars of the front of the building in the government land is illegal.
Illegal, yes. Yes. And the NHIDCL in their affidavit in opposition also say, Mother, read it of paragraph 8, the extreme right of way of the highway is up to the edge of the multi-storied building of the petitioner. The right of way is up to the edge.
Which
My lord, the affidavit in opposition filed by R4, respondent number
Dated
4, NHIDCL,
Yes, please.
paragraph 8.
14/12/2022.
Yes, Lord.
Yes, yes, my lord. Running page 56, paragraph 8, after leaving a few lines, the EROW, the extreme right of way,
Para 8.
yes, my lord, the extreme right of way of the highway is up to the edge of the multi-storied building of the petition.
The 7 numbers below the building is falls under the government land.
Even if we assume, my lord, that the 7 pillars, yes, they are government over government land, and we're not entitled to anything. The fact remains, my lord, even then the building would be at the edge of the ROW, even if the 7 pillars are ignored. If you can, we can, my lord, put it that way also. Even if the 7 pillars are ignored, my lord, even then the building is at the edge of the ROW. And that is the admitted position, my lord. No one denies that fact. They are just saying that the pillars are. The government says part of the pillar, and the NHIDCL says the pillars are the front pillars, 7 pillars. Going by the strength of the letter, my lord, by NHIDCL. I'm in any case entitled, my lord, not for the land, of course, my lord, but for the building. Demand is not quantified also, my lord. I only pray that it should be valued as per the letter. My lord.
Mr. Monto, there will be many judgments.
My lord.
You will find out.
Allah.
Wherein it shows that if the land does not belong, then also a person who has
He's
in the land would also be entitled to. Just for example, there are many persons who are, the land belongs to somebody,
my lord.
but many people have encroached upon them
Yes.
and remained for years.
Yes.
Then also they are considered to be person interested.
My lord. I'll get those judgments.
If that be so,
Yes.
then if the building is for the last 40 years, it is there. Why not? And apart from that, what is the basis for having the building? Giving the land including the building? Because they are only thinking about the land. But what happened to any other? Because in all other cases where the state government pays, they also pay the JIRA.
Exactly. In fact, that judgment authored by my lord, in that case, the petitioners were illegal encroachers, but they were there in the land. and they were paying for compensation of Jirat as well as compensation for the land. But during the course of the case, my lord, the Jirat was paid. For the buildings, they were paid the Jirat value. So it appears, my lord, if it is acquired by the government pays for the Jirat, my lord, including the value of the building.
Lordship,
I'm not paying for the.
as per last order, Lordship, I filed one affidavit. That may be Peru's Lordship. I have stated Lordship.
On 12/8,
Yes, Lordship.
well,
Lordship,
9/8,
it was filed on Lordship 9/8, my lord. In terms of,
113.
yes, Lordship, in terms of last order, my lord.
Yes, what do you say?
Paragraph 3, Lordship.
Vera?
Paragraph 3 starts, Lordship, it starts. That the whole text of the subjects has already been submitted by the answering deponent in affidavit, which is on record, and the same is not repeated.
Vera,
for-
Vera?
Lordship, paragraph 4, Lordship.
Ah.
So far
As
as to
far
the specific
as far
query
as the specific query of the
by this
remand
court,
is
wide order
concerned,
that it is concerned, Lordship.
shall file an addition affidavit. In this regard, the answer is they said that in the NAPA is an encroacher, which is an admitted fact. The petitioner encroached the existing right of way of the national highway, and therefore the petitioner is not entitled to any compensation in respect to his legal structure on the right national highway right of way. Hence, the government land means any land which is beyond the right of way of the national highway. The same is required for the common land, the compensation of land is not paid, as the same is not paid government. In certain cases, compensation can be paid by private structure of the government, land, only in the recommendation. And
2 points, Lordship.
ownership, rights of. What is this?
Lordship,
When you only pay when the government on the recommendation of Kalla, when
next better,
the
Lordship.
land are granted patta,
Hmm.
ownership right. Ownership right, that means it is not a government land.
Lordship, on the land under any law of the standing, including Abadesa. Lordship, next para, Lordship. There may be cases where people have been living on the government land for a long period, and the state government determines such persons as bona fide and genuine users of the said land. Such a right must have been created by the government through an instrument of the government, Lordship. Considering the facts and circumstances on record, the case of the petitioner does not come under the ambit of two above criteria conditions. Therefore, it is clear that petitioner is not entitled for any compensation in respect of his illegal structure on the existing right of way of the national highway. The petitioners herein are the illegal encroachers of the national highway land, which is exclusively belongs
They are
to
not
the
illegal encroachers of the national highway land.
Lordship
They became illegal encroachers as per you only after the notification,
notification.
because it was not a part of the national highway land.
Lordship.
It became a part later on. It was a
But now
government land.
that land is belongs to the national highway, Lordship. That now that land is
It
belongs,
became only in 2020.
yes, Lordship. But earlier also he's constructed that building within the right, Lordship, PWD road. Lordship.
Huh?
PWD road, that at that time that land was under the PWD, my lord. That was government land, Lordship. You want-
Understood. Let it be PWD, whatever may be, it is the PWD land. It was never a national highway land. National highway came into the picture after your 3D notification. Now, therefore, the question is, if you take away that land, he may not be entitled to any land, the compensation. But why not about the structure standing thereon?
Lordship, Lordship, constructed his building, Lordship, in the government land. That is why, Lordship.
My lord, last 40 years, I've never
Lordship,
been.
private land and government land is totally different, my lord. Because earlier also it was under the PWD, Lordship, and after handing over to the national highway, it will become the central government land, Lordship.
It was only on.
And Lordship, that is the stand, Lordship.
In fact. the
And if
circle
someone is
officer-
constructed over the government land, Lordship, they may come also for compensation, Lordship, and it will be open floodgate, Lordship.
In fact, the circle officer's report was pursuant to my complaint after the NH thing was notified. I made a complaint that it is very near to my building. Because only then the circle officer came and measured it and said that no part of this. That was for the first time in the last 40 years. I was notified that this part of the pillar is government land. I've been paying my taxes, everything. I've been never notified or never, no notice, my lord, that I've ever encroached the normal portion of the land, normal land. I made a complaint. my lord, when you said it.
Okay, we'll hear the matter. You just get hold of this.
I'll get those judgments.
Has not yet been demolished.
No.
There's a stay.
No, not a stay, my lord. What happened during the motion stage, my lord, there was a direction by this court that you get your building valued by an approved valuer, and the same task was also given to the state respondents. In case if it is demolished, then we succeed that.
That has not been.
I have valued, I'm not aware if they have valued or not. I have valued and filed an affidavit, my lord, valuation report.
Your file.
Yes. That I. The state has undertaken that exercise, I'm not aware. The first order, my lord.
Upon hearing the learned counsels appearing on behalf of the party. And taking into account the pleadings on the court. That there appears, it appears that there is a confusion. As to whether the front 7 pillars of the building of the petitioner are totally on government land and are standing on the government land or a part of the government land. The learned counsel appearing on behalf of the petitioner submits on the basis of a photograph enclosed in the petition, more particularly at page 26, that the extreme right of way have been marked in the said document, wherein it will show that a part of the pillar of the first 7 pillars falls in the extreme right of way. On the other hand, it is the stand of the respondent NHIDCL that the front 7 pillars of the petitioner's building falls on government land. This aspect of the matter can be clarified by the circle officer of the which circle?
My lord, the circle is Dergaon Moja district bola tha, circle.
Dergaon Revenue Circle.
Dergaon town.
Dergaon Revenue. And accordingly, this court fixes this matter again on 24th of September 2024, on which date the circle officer, Dergaon Revenue Circle, shall submit a report as to whether the front 7 pillars of the petitioner's building falls on government land in toto or part of the 7 pillars falls in the extreme right of way. This court have also raised the issue as to whether have also during the course of the hearing taken note of the submission of the learned counsel for the petitioner to the effect that irrespective of and had also taken note of the submission of the learned counsel of the petitioner who submits with demand that even if it is construed that the front 7 pillars fall within the government land, then also the petitioner would be entitled to the land, the damage caused to the building insofar as such demolition is carried out. The legal counsel for a petitioner further sought some time to address this court on the next date. List accordingly.
That the same picture is available with the learned counsel of NHIDC, taken independently. It was in fact shown to the court. Now why it has been not shown, I don't know. Same picture. madam.
The page, isn't that page 26?
Yes, same picture. It's available there. madam. You may have a look.
Yes, you give your report.
Item 10.
Deeply obliging. Look, hurting part, madam.
Oh, no. But you will get judgments on
I'll get
this.
judgment.
Yes, I have seen many judgments. Yes, what are these? Item?
Lordship, my prayer, my lord, the respondent authority may be acquired my patta land and give their compensation, my lord.
What?
My patta land is established.
Release the area amount of rent compensation from there till date. Yes, why you are not paying?
No, in fact, we have prepared the affidavit, but we would like to bring it on record. Already it is been ready, but from my instruction, what I can make out that he's trying to establish the fact that there has been an agreement between the deceased Okomi Ali and the superintendent of police, but from our records, there is no such agreement as claimed by the petitioner. That apart, that it is a government khas land, and from 1961 till 2010, no land revenue has been paid. And it is under the possessions of the concerned police stations since it is 67. So there is no question that the petitioner land has been taken away.
In my additional affidavit is established my.
Oh, the question is a very simple question as to whether if it is a government land, there is no dag patta. If it is a private land, there will be a patta. Go and find out and see as to whether the land is there and submit a report. Matter ends there. They say that this building is situated at the police station is situated at dag number 391 or patta number 260. That's all.
Hmm.
Does it require anything more than that? Find out.
It is a government khas land. In fact, let our
It can't be a government khas land if it is a patta land.
but that I think
So it will be in certain dag only.
yes.
So get a certificate to the effect and bring it, matter ends. Get a certificate to the effect that this land, the police station is standing on this dag, matter over. The moment it is shown that it's standing on which land, on the basis of the revenue maps, matter is over. You need so long the procedure.
In fact, our affidavit will like it will contain those facts. Let it be on record then.
Understood. So the affidavit
only
should
to that
categorically
fact
say
whether
in
this
which
dag-
dag,
Yes.
where is the dag?
There is the-
As per your instruction, which dag?
We have it, but it's
Huh?
slightly not readable. It is.
That is the
Yes,
issue.
then we have it.
Which dag?
Lordship can
No,
there will
no.
be-
Tell me, it is only 3 words. Which dag?
202. Yes.
You have instructions, you don't know where your police station is situated from 1967. Because he categorically says that he is the owner of this patta. It's a patta land. 262. So I'll give a clarification, ask them to give a patents. Huh? You don't know.
I'm trying to figure out because this is very miniature words.
No, the instructions are not there. Which dag?
Instruction says this is
They cannot come up and say very
Ask-
well that they are in government land. come up like this and say, Lahok,
Doug number 391. Yes. It is government.
that is 391 is his Dag. A patta number
262.
262 is his Dag. How can there be a government patta number? Tell me.
That's true.
How?
Because from 2000, from
How?
19.
How is it possible that a patta is being given by the government to government itself?
No, no,
Then,
cannot be.
goodness.
No land revenue has been paid from 1961 to 2010. That
Did
is-
you go for auction sale? Did you issue notice to him?
For that matter, we have to have the details because
You
ultimately
don't
there
have
has
means,
to be a procedure.
how, why the matter has been pending unnecessary or acquired the land? Lahok. The case of the petitioner herein is that the petitioner is the owner of a plot of land at measuring 1 bigha 13 lecha, covered by Dag number 391 of Patta number 262 of village Lokhiganj under Revenue Circle, Bilasipara in the district of Dhubri. It is the specific case of the petitioner that since 1967, the respondent authorities have trespassed upon the said land and have set up a police station. Police station? Police watch post. Pusto. Neither any compensation has been paid to the petitioner by the respondent authorities. It is therefore the specific case of the petitioner that the respondent authorities should be directed to pay due compensation to the petitioner. Full stop. On the other hand, Mr. S. Bulwer, the learned counsel appearing on behalf of the respondents, submits that it is a government land. This court had put a specific query upon the learned counsel as to whether he has received any instructions in which land, in which Dag number the land is situated, wherein the Lokhiganj police station, police watch posts have been situated. The learned counsel, however, submits that he has no instructions to that. List the matter again on 28th of September 2024, on which date the learned counsel, appearing on behalf of the state, shall bring on record their stand wherein the Lokhiganj police station, police outpost is situated, in giving details as regards the Dag number, etc. Giving details of the particulars of the land. List accordingly. Else acquired. Another matter is going on of Mr. B.J. Talukdar. I hope the same thing happens. They have now taken steps for acquiring.
11.
Lordship, I received one counter affidavit on 19, Lordship.
What is this?
I need to file a.
Victim compensation, Your Lordship.
Huh?
Victim compensation.
Victims compensation. You got the money?
No,
I'm
no.
sorry, Your Lordship. I might have written 12. I
Fine.
apologize.
Fine
My
is
mistake.
for-
Your Lordship.
Settlement of landlord.
I apologize. My mistake.
I
Only
received
the-
affidavit in opposition on 19, Lordship. I need to some, on that, I need to file affidavit.
Directing the respondents to settle
with
the
time by
land
bit.
within one kata agreement by allowing the. You got the allotment? Where?
Initially, Lordship, we have occupied some
Huh?
plot of government land, Lordship. Accordingly, we have
approached the honorable court in 1989. This honorable court's direction was to settle the land in terms of the Rule 14 of Assam land regulation policy. Thereafter, Lordship, a process for settlement was initiated in 2008, Lordship. Yeah, directed to the Lordship, the premium I paid. Thereafter, fresh proceeding for settlement was initiated, but till today, it's not completed, Lordship.
Yes. How can you get allotment?
Lordship, go reserve. According to them, I think they go reserve. But the Lordship, I want to place some photograph of the land, Lordship. How that can be treated as go reserve, Lordship.
Understood everything is understood, but unless they don't de-reserve it by making another place, they are not in a position to do it. You have what type of house you are having?
Lordship, mine is Assam type with boundary wall, RCC boundary wall and grill, etc. But others are, Lordship, kindly see the photograph. Government office, battalion office, another road, public PWD roads. And nearby the area, Lordship, central administrative tribunal is going to central administrative tribunal's office is being constructed, Lordship, nearby the area, Lordship.
Understood, but whether that is a gold reserve or not, how do I know?
As per a record, they are showing that go reserve, but my adjacent land, page kindly come to page 46, Lordship. Page 46. The map, Lordship. The land adjacent to me has been settled with one Saraswati Taluk.
Not give, unless they don't de-reserve it. It's impossible. Look. The petitioner in the instant case have sought for a writ in the nature of mandamus, directing the respondent authorities to bring to a logical conclusion the settlement proceedings in respect to the land which the petitioner has been possessing since decades. It is seen from the affidavit filed by the respondent number 5 that the petitioner had been wherein it is duly admitted that the petitioner has been in possession of the said land, and the government by the order date number RSS.579/93/193 dated 30/1/2008 had accorded approval for settlement of the aforesaid land in favor of the petitioner, subject to payment of the premium. But the settlement proceedings at that relevant point of time could not be completed in view of a pendency of another writ petition filed by the petitioner. Be that as it may, it was later on found that the land which the petitioner was possessing had been classified as a VGR land. It has also been mentioned that in view of the land policy of 2019, as well as the judgment of the Supreme Court in the case of Jakpal Singh versus Union State of Punjab and others reported in so-and-so, the state authorities have the state authority cannot settle the land in favor of the petitioner unless and until any reservation is made as per the procedure prescribed. The learned counsel appearing on behalf of the petitioner during the course of the hearing has drawn certain photographs. Has drawn the attention of this court to certain photographs to show that various government buildings are set up in the vicinity of the land of the petitioner, including construction is going on for setting up the Central Administrative Tribunal. Taking into account the above, this court fixes this matter again on 30/9/2024, thereby directing the respondent authorities to apprise this court as to whether any any move have been made for de-reservation of the land. In addition to that, the responding authorities are also directed to produce before this court the land records of the said dag, which the petitioner of dag number 175O/401N of village Ulubari under
Mine is
Muza
Lordship,
Ulubari.
mine is 401 Lordship.
175 old/401 new of village Ulubari.
So the both are different Lordship. Not,
It's one and the same. Old and new.
175 is the old and 401 is the new.
Understood. That is what I'm saying. List according.
During the pendency of the case, an amount of rupees 1 lakh has been granted to the petitioner and her daughter as interim compensation. And in fact, the petitioner has already received her amount, but the daughter does not possess a bank account. And so we have given her some amount of time to open a bank account, and I'm just producing that order. Singh.
That is the interim compensation.
Because the trial is yet to be completed, Your Honor. Therefore interim compensation.
Who are you?
Respondent number 3, Your Lordships, SALSA, State Legal Service Authority.
What is this compensation business?
This is victim compensation, Your Lordships. Under
Huh?
the victim compensation scheme, the
What
Assam
is this
victim.
order sheet?
Lordship, this is the order passed in the victim compensation case number 15 of 2022, which was registered by the DLSA. These are instructions which should actually come from the DLSA.
Lack of funds and then like now available with them to the direction of the victim so and so has been compensated accordingly. Okay, that is one thing. This is for interim. But the main is he's asking for 5 lakhs.
He'll get it. The trial is yet to be completed, Lordship. That is
What
why.
trial?
Lordship, the trial of the person, unless and until the trial is not complete, SALSA or DLSA does not release the whole amount, Your Lordships. We wait for the trial to be complete for the fact that, yes, this is the person who has committed the crime.
Why?
Lordships, that is the procedure which has been going on by all DLSs. I could not find any
No,
logic
that
behind
can't
it.
be there. There is a judgment of, I think, Justice Ujjwal Bhuiya when he was there.
No,
That irrespective of a person being acquitted also,
Yes.
that it can be given on the ground that there is a crime being committed. A person having died unnaturally is a crime being committed. So whether he or she would not be entitled under 357A.
Otherwise, you will have to wait for more than so many years, my lord.
Are you going to
Due-
pay
due
interest?
Independence of the trial. my lord.
That is the DLSA.
That's what I did.
I am only apprising Your Lordships. We are only the disbursing
We can't
authority,
act
Lordship.
like this. No interim compensation business. I don't think there is a concept of where is the
Lordship, they- At the relevant point of time.
where
it's
is the
not
victim
happened.
compensation scheme?
My lord.
It's annexed in the
Yes.
petition, Lordships.
Where?
Page numbers. Find it. It starts at page 30.
301.
The victim so and so procedure. Whenever a recommendation is made by the court or an application is made by a victim or his dependents under subsection 2 of IMAN to the State Legal Services Authority as the case may be, the state authority shall examine the case and verify the contents. What is the 375? Second sum, CRPC con. CRPC con. CRPC.
Then it is a below.
Yeah, আমাৰ এইটো আছে victim compensation বহুত আছে না. You don't have any order passed by me.
Today, my lord, I have not.
Huh? Go to that judge who has passed
There are
order.
separate by Your Lordship and.
Please the
just-
matter after 4 weeks. Go before that judge who has passed. My goodness.
No, maybe 6, my lord, I will produce, my lord.
Go there. After 4 weeks, there's a chance of changing the bench. You'll go there. You should have.
13.
Sorry.
I'm like.
Yes, what is this?
Lordship, today we have filed our affidavit that is not on record, Lordship, it's with regard to refunds.
What is the
May it
matter
please the
about?
Lordships.
Yes.
Lordships will recollect, my lord, this is a matter relating to refund under the Assam VAT, my lords, for the financial year 93, 94, 95, 96, and 98, 99, my lords.
Hmm.
Your Lordships had given them a last chance to file the affidavit in reply, my lords.
They filed affidavit.
On the last occasion,
Mr. B. Chaudhary, the learned counsel appearing on behalf of the state GST. State
Lordship,
Finance and Taxation Department of the Government of Assam has submitted that the affidavit has been filed on behalf of the respondents. The learned counsel appearing on behalf of the petitioner have received the copy. It is however seen that the affidavit is not a part of the records. Accordingly, list this matter again on interim order is there? No.
Lordship may have it anytime this week, my lords, because in their reply they are saying that they had lost the papers. They had lost the papers and now they have reconstructed the papers after 20 years, my lords. And now they are processing the refund, my lords. That's the only reply that they have given, my
Okay,
lords. I
then
have
we
seen
do
the
one thing, we'll have it on 11th of September. 11th of
any date
September.
next week, my lord. Any date next week, my lords, subject to your lordship's convenience.
Next week or one of the week, on 6th of September. This is the matter on 6th of September. The registry shall bring on record such affidavit, so filed by the respondents. The petitioner would be at liberty to file reply if so advised.
Lordship, please. We are obliged, my lords.
Yes, what are these? Urgency in the matter, taking into account that for the last year, the project has been withheld in view of the obstruction caused by the petitioner as well as the others in here. Yes.
This case, I have filed one interlocutory application, Lordship. That is also
For what?
for seeking permission, Lordship,
For?
to go with the construction work, Lordship. Because we have approached the authority also, Lordship, unable to carry it out, Lordship.
His case is what?
I am a patta holder of the land, but my area has been shown as a forest area, whereas my
I
my
remember.
area has been dereserved
Yes.
65 and 71.
Mr. KAC, what do you have to say?
My lord, filed affidavit, my lord, in 1965, my lord. My lord, gazette notification was issued by the Forest Department de-reserving 299 acres of land, my lord. Then, my lord, that land, my lord, was shown as a forest land, my lord. But subsequently, it came to the notice that the land was de-reserved. Subsequently, NIC decision on, my lord, 5 June 2024, issued the, my lord, first 24 April 2023, 2 villages were included for acquisition. Then thereafter, 3A notification was issued on 5th June 2024. And my lord, lordship, looking to 3F of the Highway Act, my lord. 3F of the Highway Act provides, my lord, right to enter into the land where the land is vested in the central government. Where the land has vested in the central government under section 3D.
Yes.
3F, where the land has vested in the central government under section 3D, it shall be lawful for any person authorized by the central government in this behalf to enter and do other act necessary upon the land for carrying out the building, maintenance, management, or operation of a national highway or part thereof. After publication of 3D notification, land is vested with the central government. In this particular 2 villages, my lord, where the name of some of the petitioners were there, 3D notification has not yet been published. Neither, my lord, 3D compensation amount has been determined and the funds with.
It has been determined.
Then, my lord, lordship wanted there is a meeting, my lord, review meeting by the
No. I'm asking you whether 3D notification has been issued in the case of the petitioner.
3A notification issued on
3A.
A.
The 3D not.
3 small a issued on 24.
The 3A is small a is only for competent authority.
My lord, that has been appointed in 2023 for particular these 2 villages. Then 3 capital A notification was issued on 5th June 2024.
There the petitioner's villages have been
Yes,
included.
my lord. The name of the certain petitioners were there. We have filed the affidavit, my lord. On, my lord, 12th August, my lord, Chief Secretary reviewed it, my lord. As the 1971, my lord, another 299 acres of lands were de-reserved, my lord. And in those lands also pottas were issued. And the gazette notification in respect of that another 299 acres, that it is not with us, my lord. So the Chief Secretary reviewed it and asked the Principal Secretary of Revenue and Disaster Management to look into it. And in that particular meeting, response number 10, NIC research were also present. That is the last, my lord, review meeting was held, my lord. The 3D notice has not yet been published.
Then how do you enter?
Lordship. Lordship, one part, there is a 1.5 kilometer, Lordship, that is under the forest land, Lordship. And for that part, Lordship, we are unable to process the work, Lordship.
Forest land, if it is a reserve forest, how have we done it?
No, Lordship, that is forest land, and in this regard, Lordship, Environment Forest Department also issued the forest clearance, Lordship, to go with the work, Lordship. And accordingly, we have deposited the amount, Lordship.
To whom?
to Lordship before the authority, Lordship.
Why?
Because Lordship, kindly peruse the annexure.
You, in your earlier affidavit, in the earlier case, you say the government land you don't pay.
No, Lordship, this land belongs to forest land, Lordship.
The
And
forest-
for
forest
forest
is
land,
not
Lordship,
government.
for with the construction work, we have to obtain the permission from the forest clearance, Lordship. And accordingly, forest clearance has been given by the authority concerned, Lordship. So
But
Lord-
what about the petitioner's land,
Lordship,
where the
petitioner's
patta is
land is
there?
different, Lordship.
So you are not going to disturb the petitioner's
Yes,
land?
Lordship, we are unable to work that particular, that 29 acres of forest land, Lordship.
Show me, where is the 3D notification?
First, look into our affidavit file, my lord, is, my lord, we have annexed it, my lord.
Response number 9. Your response number 9,
Response number 9.
page 253.
Notification we have annexed, my lord, lordship, look into paragraph 4, is 309.
Okay. And you agree for issuance of the patta?
Well, we have already issued the patta, my lord, in 1971 itself, my lord, 65 and 71.
Kilometer 50 plus 710 to Iman, Iman to Iman, 3A issued, 3D issued. Second
has
page,
not yet been
3A,
issued.
3D issued, 3G order, so and so. Okay. But where is the 3C?
3D has not yet been issued.
Huh?
3D has not yet been issued, my lord.
No, in some section, 3D has been
But
issued.
some section has been issued, my lord, particular in respect of particular these two villages. Where the earlier it was shown as forest, now it has been shown as a revenue village. my
Which
lord.
villages?
That is my lord Poritaro and my lord 3 number Sildampur. Lordship, look into it. Is notification we have annexed it, my lord. That first 313, my lord. These two villages are there. 313 page, name of the village Poritaro and 3 number Sildampur.
313.
313. Column number 7.
313.
That is 49 to 155 kilometer in respect of these two villages.
Wait. 313 is what document again?
That
There
is
is
a-
another affidavit filed by, this is a reply filed by the petitioner.
This additional affidavit we have filed, my lord.
When? Additional affidavit,
My lord.
yes. Page
313.
313. Yes, what is
My lord,
this?
column number 7, these two villages, Poritaro and 3 number Sildampur.
So here, it is only a competent authority.
My lord, next page is the 314. There is a 3A notification. English portion is at, my lord, page 317.
Page,
317.
this is what land?
That is, my lord, package 250, that particular land, my lord.
This is
Of these two
area
villages.
from 50 to Iman.
Description of this, let's see the next 318.
318.
Village Poritaro,
Horitaro and
3 number Sildampur.
Siddharampur.
Sildampur. And the land of the, my lord, of serial number 6, 9, 51, 59. That the petitioner lands were, my lord, notified by.
Okay, these are petitioner's land.
Petitioner's land, my lord.
Then,
The 3D notification has not been issued in this particular notification, my lord. We have sent it to the NSA.
so we can very well say that they can go ahead, accept these
My lord,
unless they go ahead with the 3D.
that is one part, my lord. Another part, if your lordship look into our affidavit, my lord. Our affidavit, my lord. Page 274, my lord. No, page 270, my lord, first.
Uh,
The problem arises here, my lord.
uh,
There is a letter dated 13/3 to 1970.
uh.
That is from the Forest Department to the Commissioner of Forest, Upper Assam, my lord, de-reservation in Sildampur Reserve Forest.
With reference to your letter, Sadirwa, I am directed to say that the Governor of Assam is pleased to de-reserve the vacant plot adjacent to the previous de-reserved 299 acres of Silrampur Reserve Forest for settlement of some eligible landless agriculturist divisional forest officer and Nagaon division may be asked to work out the actual area for de-reservation. After that, the de-reservation notification with necessary map may be sent to this department for publication in the Assam Gazette. Then, my lord, copy to the Deputy Commissioner Nagaon, my lord, it is relevant, my lord, that a petition from so and so other is enclosed here for giving them settlement. And they are found landless. Name of the list be asked from the petitioner. He is also requested to select someone so and so. Next, my lord, lordship will look into page
273.
273, my lord. I am directed to say the government are pleased to de-reserve a portion of land measuring 299 acres approximately in Silrampur Reserve Forest near the previously de-reserved area under the government letter number dated so and so to settle some landless people headed by so and so. Now the RF has been transferred to the district council for management. You are therefore requested to work up the actual area of de-reservation. After that, the de-reservation notification may be sent to this department with this necessary map publication for in Assam Gazette, my lord. That is the second notification, second communication, my lord. Here is
Published
also
in the Assam Gazette on 13/10/1965.
19, my lord. Earlier, my lord, that two villages I have already pointed out, my lord. That is in respect of the 1965, my lord.
Which two villages?
This Horikaru and Silrampur, my lord. That is the 299 acres earlier de-reserved. And 1970, another 299 acres were de-reserved, my lord. And that particular, my lord, gazette notification and my lord, that is which not with us, my lord. So it is the chief secretary, my lord, asks the principal secretary to coordinate it with the, my lord, forest department and to find it out, my lord, to a settlement. And that has been communicated, and he was respond number 10, NSCDCL were present in the meeting. And we have stated in this affidavit, my lord, specifically regarding the meeting with the chief secretary conducted by the chief secretary, my lord. That is, my lord, which one? There is paragraph 7, page 1, my lord. Additional affidavit.
Of which affidavit?
Well, some additional affidavit, my lord.
We do one thing, this will take some time,
My lord.
some other date. But this matter requires an urgent
My lord, my
disposal.
lord. Well, it is
That
regarding
can be
hearing, my
fixed
lord.
today, but there are so many other matters fixed by other courts.
Hearing is required, my lord, in this matter. Only this complex issues is there, whether those people who were settled there in 1971, whether they will compensation or not, my lord. Whether 3A, 3D notification to those people, my lord. That we have already issued the pata in
No,
1971.
3D notification has to be issued.
But in this respect of two
Whether they
villages,
pay compensation is another aspect of the
My lord.
matter, but 3D, without 3D, no, the right does not rest
my
upon.
lord.
Because
This is-
3D is required.
Particular in these two villages. But in
But in
respect of the
3A
299 acre reserved in 1970, that is the issue whether those people will get the compensation or whether 3A notification is required to be issued or not. That point has not yet been decided, could not be decided, my lord. So that as we don't have that gazette notification, forest was transferred to us, my lord, in 1995, and it is a document of 1970. So we wrote to the government also whether the gazette notification not published, whether those land were demarcated in the from the forest or not, my lord. These issues has not yet been resolved, my lord. So this particular area, my lord, only this particular area, two villages are there. Those two villages are affected, my lord. Construction could not be done in that particular, those two villages, which are falls under
Which is this road from?
From my lord, it is my lord, Doboka to my lord, Dokmoka to Paroko. Dokmoka to Paroko. That one space is there.
Oh, yeah, that forest
One,
area.
yes, my lord, that one space is there that was not
But that is
constructed.
very deep, very intense
Yeah.
forest.
My lord, in the one side forest is there, in other sides the agricultural fields are there. If your lordships going there,
But
That-
not in that area, no?
not
There
in
is
the
one
reserve forest
which
area.
is completely forest.
My lord, I have the topograph sheet also that has been furnished to me, my lord. That area, if you lordship, looking into the map also, that has been shown as a village area, my lord. In the topographic area that has been conducted, my
You
lord.
mean to say the entire chunk of the
Not my lord,
forest?
only a part, my lord, only a part of the Silthampur Reserve Forest that has been de-reserved. Others were already, my lord, reserve forest has been declared. It is a government reserve forest, not the district council reserve forest. And it is in the, during the British area, my lord, that has been reserved forest. And it was de-reserved in 1965 and
But that
1970.
portion falls in the other, not KAC, the main portion, I think that portion falls with the other one, what do you call the Biswanath? No, no,
There
Huzai subdivision.
my lord.
That
The
falls. in
Doboka part is
The-
there, where the
yeah.
construction has not yet been, that part is Huzai district.
Huzai.
Doboka,
And
that
beyond that,
trees are
after
there.
that, I think it is
Yes,
the
my lord, yes, my lord.
AC starts after the forest.
After that portion.
But
my lord.
just there are some villages, that is the area.
That's there.
But what are you doing with that area?
Lordship, Lordship, I have filed this interlocutory application to go over the work in 1.5. Lordship may peruse annex at page 48, my lord. That will be clear, my lord.
Of the IE?
Yes, Lordship. We want this, Lordship, for portion of this construction required, Lordship.
Page
48, my lord, annex 8. Land acquisition and forest issue in Parakpa to Dokmoka section package to land 29, Lordship. For this portion, Lordship, we want to go with the work, Lordship. Only 1.5 kilometer is, Lordship, we are unable to complete the
No,
road, Lordship.
understood, but
And that road belongs to the forest.
but are these lands not their lands?
Not their Lordship. This
Whose
is
land?
forest land. Forest land, my lord.
How for, they have been issued patta as per the
No, no.
state, even the Kala. Who are you to say?
Lordship,
No, who are you to say?
Lordship, we have got the forest clearance.
TCL has no business out there. You are no the overall control over the revenue. The revenue is either the Kala would be there. You have appointed a competent authority who will be doing it. You are only a requiring agency. Who are you to say? You can't say that this land is this land is that.
No, Lordship, we are
That
saying
is
on the
part
basis of,
transgressing upon your authority. Don't take that land.
Lordship, we are,
Allah, don't give them land. We direct that. You can't by yourself dictate out there. Then look here, I want this land, but we say that this is reserved forest. This is not reserved forest. This is government land. We are not going to pay. These authorities will know. Who are you to say that? You can't say that this is that. They are the better person to know what is the government land or not. They categorically say that we have issued patta. Matter there. If it is a reserve forest, impossible. Forget about the road. We don't require roads over reserve forests.
There are two meetings held, my lord. One is the council that respond number 10, general manager was present. Chief secretary meeting, respond number 10 was present on 12th August, my lord. And it was decided that that the government will look into it between the coordinate between the forest department and the revenue department. And the chief secretary asked the, my lord, principal secretary of the revenue department to look into it and to come to a conclusion, my lord. So after conclusion, my lord, they can, my lord,
Yes,
that is the point.
You are only making construction and paying them the compensation. Nothing more than that. Mr. Sutia, how long it will take?
My lord, that's the minutes of the meeting, my lord.
This matter is
Then
not
it was-
urgent. Matter is not urgent. This will wait till this is being
See, my lord,
finalized.
these have been
What?
settled by the
Goodness.
government of Assam, my lord,
Huh?
regarding the gazette notification
Yes.
and all these things, my lord.
It's too much. Where is that minutes?
My lord, para 7, my lord, we have annexed it, my lord. We could not get it on that, my lord. Minutes is not at this moment with me, my lord. So we have stated in the affidavit that the chief secretary to the government of Assam reviewed the issues involving de-reservation of Silthampur Reserve Forest on 12/8/2024, in which the principal secretary, revenue and disaster management, officials from Forest and Environment Department, Secretary Kaasi,
Which
other
paragraph?
officials Kaasi were present. The general manager NSA DCL, the response number 10 has also participated in the meeting. The earlier paragraph, we have handed over all the papers to the general manager, my lord. Paragraph 6 also in the meeting, Last para, General Manager NICDCL was also present and the gazette notification dated to ensure and communication dated to ensure was handed over to the General Manager NICDCL for taking the decision.
Are you against acquisition or not? Are you against the acquisition?
We are not against acquisition, we were just, we should get our due compensation.
Okay. In both the writ petition, the issue involved is as regards whether the petitioner herein would be entitled to compensation upon their lands wherein the Karbi Anglong Autonomous Council have duly issued pattas On the other hand, the NHIDCL maintains a stand that the lands are forest lands, and as such, the petitioners herein are not entitled to any compensation. This court have also heard Mr. J. Sutir, the learned counsel, standing counsel of the KAAC, who submits that two plots of land, each measuring 299 acres, were de-reserved in the year 1965 and 1970. And against that, land has been, pattas have been issued to some of the petitioners. Taking into account that in the year 1995 only, the forest was handed over to the KAC, and earlier the documents were maintained. Earlier, the forest was maintained by the state of Assam. A meeting was convened on 12/8/2024 with the Chief Secretary, wherein the General Manager NHIDCL, who is the respondent number 10, was duly present. He further submitted that in view of the discussions which are going on, a solution is sought to be arrived at mutually as to how to proceed with the acquisition of the land in question. He therefore submits that some time may be given to the officials to finalize these aspects. Taking into account the above, list this matter again on 17th of September 2024.
3D notification has not yet been published, my lord, in respect of these two villages also.
17th of September 2024. This court, before parting with the record, this court, however, finds it relevant to observe that observe the submission of Mr. R.K. Talukdar, the learned counsel, appearing on behalf of the respondent number 10, who submits that that this court should pass appropriate directions so that the respondent number 10 can proceed with the execution of the work. It is, however, relevant to take note of that on 24th of April 2023. Very relevant to take note of. That on 5th of June 2024, the notification under Section 3 capital A of the National Highways Act 1956 was issued. In respect to the village, Horitaro and
Silrampur,
Siddharampur,
3 number Silrampur. Silrampur.
in respect to village Horitaro and 3 number Siddharampur. However, till date, no notification has been issued under Section 3D of the Act of 1956. Consequently, without a notification under Section 3D, the power to enter under 3F cannot be exercised. Accordingly, taking into account that the officials are presently dealing with the said respect to the matter, this court is not for the present inclined to pass such directions as sought for. The same shall be considered on the next stage.
Lordship, I have submitted that 1.5 kilometers not on forest land that may be recorded in my lord.
Which one?
That land, lordship, land 1.5 kilometer lordship. Dokmoka
Which
bypass,
village?
which we are seeking for consent. That lordship, Parakwa to Dokmoka section to package to NH 29.
I have to my instruction, some of the lengths of the petitioners are there, which is 1 or 2.
Will consider 17.
And moreover, Lordship, there are 2 kinds of approval. They have only received first approval. There are other approvals also.
We'll see in the
Item 14 for orders.
Why order? Yes.
On last occasion, your lordship, the honorable court has directed to file the reply. I have filed the reply today, your lordship.
What is this type of cases?
My lord,
Yes, your lordship.
this particular case is not survive, your lordship. If your lordship, kindly peruse your lordship, the last interim order passed in 26/8/2022, your lordship. That is flag, yellow flag, your lordship. Here in second para, your lordship. According to the petitioner, your lordship, the license agreement entered by the petitioner with the IRCTC authority is valid till 15 November 2022. Because they have taken the shelter of this tri-party agreement, your lordship, which is actually my submission at that on 26/8/2023. It is not an agreement. It is just for the taking over from railway to IRCTC. That we signed tri-party agreement. This is not an extension, and that this particular petitioner is running from from 1993 till now. From 1993 till now, and your lordship, prior to that, we have finalized the tender, but we could not finalize. We have to discharge the tender because of the interim order.
Lordship, kindly have my reply.
What reply? Your entire agreement basis is 15/11/2022.
Because
You have no business of this.
And your lordship,
No,
your lordship, this is the
last order.
Who are you?
Last lordship.
Upendra Pal.
Lordship, kindly have. The Honorable Supreme Court has also been granted, your lordship, kindly for the
this is the last tender. They have challenged this particular tender was
Supreme
challenged.
Court has done what?
the renewal of the, your lordship, RR has been allowed, your lordship.
RR?
Railway replacement room. This was allowed by the Honorable Supreme Court.
Where?
Yes, your lordship, kindly have page number 150.
150.
And now the contempt petition has been filed there, and they have specifically stated that they have complied.
115?
150, 150.
Today you have been through.
My
150.
carry.
Yes.
The issue raised in these cases pertain to renewal of the license of the appellants by railways. It is fairly submitted by the Railway Council on the both parties that the issue in principle is covered by the decision of so and so, decided on so and so. Therefore, these appeals are allowed, directing the railway to take the required action in light of the said judgment within 6 months. The impugned judgments are set aside and appeals are allowed as above. Thereafter, the issues on renewal of the license in principle is covered by the decision of so and so. Therefore, these writ petitions are disposed of with direction to the railways to take the required further steps in the light of the said judgment, so and so, Your Lordship. Thereafter, Lordship, page kindly have page 152. The one petition from the Honorable High Court, Allahabad, was rejected on the ground of renewal. And that was further, Your Lordship, it was considered by the Honorable Supreme Court. Page 153. Leave granted in SLP so and so, application for improvement 177 of 2015. The petitioner is a part of 177 of the 2015, Your Lordship. The appeals are allowed and the petitions are disposed of in the terms of so and so. Non-reportable judgment.
Go to Supreme Court, go to Supreme Court directly.
Your Lordship, for a moment.
Without, I pass an order so that you don't need to even have the problem with the writ appeal. Direct go to
Second
Supreme
participant
Court.
also will be going for the first
That
standard.
is the proceedings of the 2016 order, which was reported out there. And thereafter came the 2017 catering policy. And therefore, this was the order in pursuance to that. Nothing out
Your
there.
Lordship, for a moment.
Lepo,
The matter.
you when? I'm vacating the interim order.
The matter of
Vacating the
petitioner.
interim
Your Lordship,
order.
for a moment only. Kindly have annexure number, Your Lordship, for 1, 2, 3. Annexure number 1. For a moment, Your Lordship.
No.
Your Lordship, the matter of the petitioner is not covered by the 2017. For a moment, Your Lordship, I have annexed the categorization of the railway station of the petitioner. Alipurdwar is not come under the grade A1 station. It has been come under the NSG 4, Your Lordship. It is come within the circular of 22/2017. Kindly have page number 123, Your Lordship. 123.
No, your agreement is on the basis of this tripartite agreement.
No, Your Lordship, kindly have on 15/11/2017, the railway has given the categorization of the station, where my station
Page.
Your Lordship, 123. 123.
Yes.
My lord. May I please?
Yes.
New Delhi, 15/11/2017.
What is this?
This is the
At
categorization.
page 123, the date has been put with something. What is this type of area?
Because the categorization of the railway station.
So what is this? The date, why the date is not there?
Date is there, Your Lordship.
Where?
Here.
Read the date. Read the
15/11.
date, read the date.
15/11/2017.
How do you get the 17? I don't have a 17. Mr. Singh, you have the 17? No 17.
Your Lordship, kindly have.
Where is the 17?
17.
Where is the 17?
Lordship, it may be verified because it is the paper of the railway, Your Lordship. And thereafter, Your Lordship, kindly have.
Release the
Yes.
matter on 31/8/2024. Matter one.
The interim order has.
Absolutely no.
25.
You those only say before the authorities out that 31/8 it is there.
31st Act.
Huh?
31st, Your Lordship.
31/8/2024.
Because, Your Lordship, I have to come from the outside. I have to come from the Allahabad, Your Lordship.
Please come. It is Saturday.
Your Lordship.
This Saturday, I'm keeping it. This Saturday. Not far away. Don't go. And enjoy your son.
Because 9th September has been fixed by Your Lordship in another matter. Kindly fix the 9th.
When?
9th September. Your Lordship have fixed already in your one matter, Your Lordship. 9th September.
No, do video conference. 31/8. We don't have time.
Yes.
Yes, Mr. Mohanto.
Consider, Your Lordship. Because I have
31/8.
I have to be a Aurangabad, Your Lordship, because there is urgent matter, Your Lordship.
Riki
It has already been filed, Your
What is
Lordship. Your Lordship, kindly. My humble request, Your Lordship, may consider. Have it on 9th September, Your Lordship. I have to come here.
Next day.
Next matter to decide.
9 September.
Yes, next.
Lordship, 9 September. My humble request.
The matter on 9/9/2024. This court, taking into account that the interim order was passed on the basis of the that the agreement would be in existence only up till 15/11/2022. This court, having taken into account
15 November
that the
2022.
interim order was passed on the basis that the agreement would come to an end on 15/11/2022, and the period have lapsed, is not inclined to extend the interim order. 9/9,
9 September.
9th of September. Yes, what has happened?
We are being evicted.
Evicted? Now what, yes, government, what have they done? Has the government come up with anything? I've asked the government to come up with a stand as to what have been happening as regards alternative locations.
After some time, Lordship.
Eh?
After some time, Lordship.
Okay. List the matter tomorrow at 2 o'clock.
Okay.
Get your instructions,
Okay.
because you see, I permitted you to evict them, subject to also getting an information how the petitioners could be relocated.
Lordship.
You were therefore, you must have had the copy of the order.
Lordship.
And if you had the copy of the order and you have not, tomorrow at 2 o'clock, we may ask that person to be present. Get your instruction.
Lordship, also one more thing, with regard to the respondent number 4, we tried to take justice service, they refused, Lordship.
Okay, who is respondent number 4?
Kapoor Municipal.
Yeah, they are not bothered now. No, you have been evicted. We have only as regards this. List the matter, on so and so at 2 p.m. On which date the state council shall the council appearing on behalf of the district administration shall positively obtain instructions in terms with the order dated
14/8/24.
14/8/2020. Yes, Mr.
Item 15 and 16. Hearing matter otherwise, but matter has become infructuous matter.
I'm sorry.
Not
This is a very interesting way of. This is something they ought to have, the process ought to have been initiated almost 2 years back. Now that today they issue a notification.
Lordship
And
may
somewhere
have
has a
to
copy.
look at the notification.
Not at all infructuous. I'm sorry to say. This is,
What
I
is
would
the
rather
matter
say
about?
they are in contempt of the.
Hello, their prayer is for undertaking an exercise of delimitation. This is a notification of for undertaking the exercise of delimitation. So all their prayers are met. Lordship may kindly have a look at the notification.
You have filed an affidavit.
Be with instructions.
You bring it on affidavit. We'll take it up on Thursday.
Lordship may just have a look at this. And their prayer. We'll file an affidavit. All the 3 prayers made by them in the written petition will be taken care of by this notification.
List the matter on Thursday at 2 p.m. Thursday, yeah? Have it on. On Thursday, we are fixing Mr. Mazumdar.
For Thursday, those company matters, long matters can it be taken up Friday?
It doesn't take time. He is going to, your submission is infructuous.
Minor.
So Mr. Dhor can very well say that.
Minor.
And for him, because the matter came up last time, I remember. And when Mr. Dhor was saying that Mr. Mazumdar is there, so I can't argue. But he has the argument.